The Companies Act, 2013. Frequently asked questions. The Companies Act, 2013 constitutes India's definitive corporate governance framework, superseding the Companies Act of 1956. This legislation introduced strengthened regulatory oversight, enhanced corporate transparency, and elevated governance standards for all business entities operating within Indian jurisdiction. What is the Companies Act, 2013? A comprehensive legislative framework governing the incorporation, regulation, and dissolution of companies in India, replacing the Companies Act of 1956 to address contemporary corporate challenges and regulatory needs. Why was the new act implemented? The act was established to elevate corporate governance standards, enhance operational transparency, strengthen regulatory mechanisms, and align India's corporate law with global best practices in response to the evolving business landscape. To whom does this act apply? The legislation governs all corporate entities operating in India, including private and public limited companies, one-person companies, foreign companies with Indian operations, and not-for-profit organizations registered under Section 8. What are the key innovations in this legislation? The Act introduced substantial improvements in corporate governance, mandatory disclosure requirements, and regulatory compliance. Significant innovations include mandatory corporate social responsibility, provisions for class action suits, recognition of one-person companies, and heightened director accountability. When did this legislation take effect? The Act received presidential assent in August 2013 and was implemented in phases. Most provisions became operational by April 2014, with select sections activated subsequently. What are the primary compliance requirements? Companies must fulfill numerous compliance obligations, including timely filing of annual returns and financial statements, conducting regular board and shareholder meetings, maintaining statutory registers, adhering to director appointment protocols, and ensuring proper related party transaction disclosures. How does the Act protect investor interests? The legislation strengthens investor protection through expanded shareholder rights, comprehensive financial disclosure requirements, establishment of the National Financial Reporting Authority for accounting oversight, provisions for class action litigation, and more stringent penalties for fraudulent activities. What penalties exist for non-compliance? The Act establishes a graduated penalty framework ranging from monetary fines to criminal prosecution and imprisonment for company directors and officers, with sanctions proportionate to the violation's severity and potential impact. What constitutes corporate social responsibility under this Act? Section 135 requires companies exceeding specified financial thresholds, net worth of 500 crore, turnover of 1,000 crore, or net profit of 5 crore, to allocate 2% of their average net profits from the preceding 3 financial years toward approved CSR initiatives. How does the Act affect company directors? The legislation defines directors' fiduciary responsibilities with greater precision, imposes directorship limits, 20 positions maximum, with a sublimit of 10 for public companies, mandates female representation on boards of specified companies, and establishes comprehensive qualifications and responsibilities for independent directors. Arrangement of sections. The Companies Act, 2013 is structured into 29 chapters, each addressing specific aspects of corporate regulation in India. This systematic organization enhances accessibility and facilitates comprehensive understanding of the legal framework. Key questions regarding the organization of the Companies Act, 2013. How is the Companies Act, 2013 organized? The Act employs a logical structure, divided into chapters and sections, that comprehensively address the entire corporate life cycle. This methodical arrangement progresses from company incorporation through operations and management to dissolution, providing a coherent and integrated regulatory framework. How many chapters are in the Act? The Act comprises 29 chapters encompassing 470 sections. Each chapter focuses on a distinct aspect of corporate governance, collectively establishing a comprehensive regulatory framework for companies operating within Indian jurisdiction. What do the different chapters cover? Each chapter addresses specific corporate functions and regulatory requirements. For example, Chapter 2 governs incorporation procedures. Chapter 7 delineates management and administration protocols. Chapter 8 details share capital and debentures. Chapter 9 covers financial statements and accounts, and Chapter 15 addresses corporate restructuring through compromises, arrangements, and amalgamations. Why is the arrangement of sections important? The systematic organization enables stakeholders to efficiently locate and comply with relevant provisions, This structured approach streamlines compliance by allowing companies to precisely identify applicable regulations without navigating the entirety of the legislative text. How do I cite a specific section of the Companies Act? Proper citation includes both the section number and the Act reference. For example, Section 149 of the Companies Act 2013 specifically references the statutory provisions governing the appointment, qualifications, and responsibilities of independent directors. Are there any schedules in the Act? Yes, the Act incorporates 7 schedules that supplement the main provisions with detailed specifications. These schedules contain essential forms, procedural guidelines, and tabular information that elaborate on and operationalize the core statutory requirements. How are the chapters numbered in the Act? The Act utilizes Roman numerals I, II, III, etc. for chapter identification, while sections employ standard Arabic numerals I, II, III, etc. This differentiated numbering convention facilitates precise reference to specific statutory provisions. Have there been any amendments to the original arrangement? Yes, the Act has undergone several amendments since its 2013 enactment to enhance regulatory effectiveness and address emerging corporate governance challenges. While these amendments have modified, added, or removed certain provisions, they have generally preserved the fundamental chapter architecture of the original legislation. Chapter I, Preliminary Chapter I establishes the foundational framework of the Companies Act, defining its jurisdiction throughout India and providing essential terminology that governs interpretation of the entire legislation. What is this law called and where does it apply? This legislation is officially titled the Companies Act 2013 and extends jurisdiction across the entire territory of India. The Act clearly specifies implementation dates for its various provisions and precisely delineates its applicability to different corporate entities. How do I understand the specialized terminology used in this Act? Section 2 provides comprehensive definitions for all critical terms used throughout the legislation. It offers precise interpretations of key concepts such as company, director and officer, ensuring consistent application of regulatory provisions across all corporate contexts. When did this Act come into effect? The Companies Act 2013 received presidential assent on August 29, 2013. Implementation followed a strategic phased approach, with different sections activated on various dates as specifically notified by the government, facilitating a systematic transition from the Companies Act 1956, which companies are subject to this Act. The legislation governs all companies incorporated in India under either this Act or previous company laws. This encompasses the full spectrum of corporate entities, private companies, public companies, one-person companies, and foreign companies operating within Indian territory. Can the government grant exemptions from compliance with this Act? Yes. Section 462 empowers the central government to exempt specific companies or categories of companies from particular provisions. Such exemptions must be officially published in the Official Gazette, accompanied by a detailed explanation justifying the regulatory exception. How are legislative conflicts resolved? Section 465 establishes clear guidelines for resolving conflicts between the Companies Act and other legislation. As a governing principle, the Companies Act supersedes earlier laws addressing identical subject matter. However, specialized industry-specific legislation may take precedence in certain well-defined circumstances. Chapter 2, Incorporation of Company. Chapter 2 establishes the fundamental requirements for company formation in India, outlining the membership criteria, mandatory documentation, registration procedures, and operational obligations that founders must fulfill to legally establish and operate a company. How is a company formed? Company formation requires a minimum number of members, 7 for public companies and 2 for private companies, 4 as specified in Section 3. These founding members, subscribers, must sign the company's memorandum and each subscribe to at least 1 share to establish their legal membership status. What documents are required for incorporation? Every company must prepare 2 foundational documents, the Memorandum of Association and Articles of Association. The Memorandum, Section 4, defines the company's name, registered office location, objectives, and capital structure. The Articles, Section 5, Establish the internal governance rules governing shareholder meetings, director appointments, dividend distributions, and other operational matters. Both documents must be properly formatted, organized into numbered paragraphs, signed by all subscribers, and filed with the registrar. What is the registration process? Company registration. Section 7 requires filing specific documents with the registrar, including the memorandum, articles, compliance declaration, address verification, director and shareholder information, and prescribed fees. Upon verification of all submitted materials, the registrar issues a certificate of incorporation, which serves as conclusive evidence of the company's legal existence and compliance with all registration requirements. Why is a registered office necessary? Section 12 mandates every company to maintain a registered office, which establishes its legal domicile and jurisdiction. Companies must notify the registrar of this address within 30 days of incorporation, display their name and office details prominently at all business locations, and communicate any address changes to the registrar within 15 days through prescribed forms with supporting documentation. This registered address serves as the official point for all legal communications. What naming restrictions apply to companies? Sections 4.2 and 4.3 prohibit company names that are identical or confusingly similar to existing companies, falsely suggest government connections without proper authorization, or contain restricted words. Additionally, companies must prominently display their name and registered office address on all business correspondence, websites, invoices, and official publications to maintain proper corporate identity and transparency. Members' liability. Frequently asked questions. Companies must maintain minimum membership requirements. 7 for public. 2 for private or members aware of the shortage become personally liable for company debts incurred during this period. This liability arrangement is codified under Section 10 of the Companies Act. What happens if a company has too few members? If a public company operates with fewer than 7 members, or a private company with fewer than 2 members for more than 6 months, the company forfeits its limited liability protection for a fundamental benefit of incorporation. Who bears responsibility for company debts in this scenario? Any member aware of the membership deficiency becomes personally liable for all company debts incurred during this period. This liability extends beyond their capital investment to their personal assets. What is the purpose of this provision? This rule ensures companies maintain legally required minimum membership thresholds, prevents the operation of improperly constituted businesses, and protects creditors and the public from engaging with companies failing to meet essential legal requirements. Is the liability distributed or individual? The liability is several, meaning each informed member can be held individually responsible for the entire debt, not merely a proportional share. Creditors may recover the full amount from any single member with knowledge of the deficiency. Can companies add new members to avoid this liability? Yes. Companies falling below minimum membership requirements should promptly recruit new members to avoid triggering this liability provision. The 6-month grace period provides reasonable time to address the shortage. Does this rule apply when members die or resign? Yes. The rule applies regardless of the reason for the membership shortage. Companies must replace departing members within the 6-month grace period to maintain proper legal status and limited liability protection. How can a company establish a member's knowledge of the shortage? Knowledge can be demonstrated through meeting minutes, correspondence, or documentation showing the member was informed about or participated in discussions regarding the membership deficiency. In some instances, a member's position in the company may create a presumption of knowledge. Are there exceptions to this rule? The Companies Act provides no specific exemptions to this requirement. However, companies undergoing winding up proceedings or those that have filed for insolvency may be subject to different liability provisions under their respective legal frameworks. Memorandum of Association. Frequently asked questions. The Memorandum of Association constitutes the founding charter of a company, establishing its fundamental identity, purpose, and organizational structure. This pivotal document, while foundational, can be modified post-registration through prescribed legal procedures. What must be included in a Memorandum of Association? The memorandum must clearly state the company name, registered office location, business objectives, limitations on member liability, and authorized share capital details, as stipulated under Section 4 of the Companies Act. Are there restrictions on company name selection? Yes. Company names cannot be identical or deceptively similar to existing registered businesses. Names must comply with all statutory regulations and cannot contain elements deemed objectionable by relevant governmental authorities. Can a company amend its memorandum after registration? Yes. Companies may modify their memorandum by securing a special resolution, requiring 75% shareholder approval, and following mandatory procedural requirements, including obtaining all necessary regulatory clearances, as outlined in Section 13. How does the memorandum differ from Articles of Association? The memorandum defines the company's external relationships and fundamental constitutional parameters, while the articles govern internal operational procedures and establish the framework for relationships among members. Is the memorandum available for public inspection? Yes. Upon formal registration, the memorandum becomes a public document accessible for examination by any interested party, ensuring transparency regarding the company's constitutional foundation and business objectives. What are the consequences if a company operates beyond its memorandum scope? Actions exceeding the memorandum's defined scope may be classified as ultra vires, beyond authorized powers, and potentially declared invalid. Although contemporary company legislation has substantially mitigated the practical impact of such restrictions, who must sign the Memorandum of Association? The memorandum requires signatures from all company subscribers, founding members, each committing to acquire at least one share. These signatures must be properly witnessed in accordance with statutory requirements to ensure legal validity. Articles of Association. Frequently asked questions. Articles of Association define a company's internal governance framework, potentially including special entrenchment provisions for organizational stability, and can be modified through special resolutions with appropriate regulatory approvals. What must be included in the Articles of Association? Articles must outline the complete framework for company management and operations. They should address all matters specified under Section 5 of the Companies Act, including governance structure, shareholder rights, and decision-making protocols. What are entrenchment provisions? Entrenchment provisions are protective clauses that establish stricter requirements for amending specific sections of the articles. These provisions exceed the standard special resolution threshold, safeguarding fundamental company principles from casual modification. How can Articles of Association be changed? Articles can be amended through a special resolution requiring approval from at least 75% of voting shareholders. This procedure applies to all modifications, including conversions between private and public status. Some amendments may require additional regulatory approvals based on their nature. What's the difference between memorandum and Articles of Association? The memorandum defines the company's external relationships and foundational structure, while the articles govern internal operations, including member rights, meeting procedures, dividend policies, and decision-making processes. Are there standard templates for Articles of Association? Yes. Companies may adopt model articles provided under the Companies Act, customize these templates to suit specific business needs, or create entirely custom articles tailored to their unique operational requirements and shareholder arrangements. Can articles restrict share transfers? Yes. Private companies often include share transfer restrictions in their articles, such as preemption rights requiring shares to be offered to existing members first, or provisions requiring board approval for any proposed transfers to new parties. What happens if company actions violate the articles? Actions that contravene the articles may be deemed void or voidable under company law. Shareholders can initiate legal proceedings seeking remedies such as specific performance orders, injunctions, or declaratory relief to address violations of the articles. Incorporation. FAQs. Incorporation transforms your business into a distinct legal entity, with its own rights and liabilities through a methodical process of document preparation, submission to the registrar, verification, and official certification. What documents do I need to prepare for incorporation? Essential documents include the Memorandum of Association, Articles of Association, and statutory forms. These establish your company's fundamental framework, detailing its name, registered address, objectives, share capital structure, and the specific roles and responsibilities of directors and shareholders. How do I submit my incorporation documents? Submit all documentation to the Registrar of Companies either through the official online portal, requiring digital signatures and electronic payment, or in person at the Registrar's office, requiring physical documents with original signatures. What happens after I submit my documents? The Registrar conducts a comprehensive review of your submission to verify legal compliance and completeness. This process typically requires several business days. If any issues are identified, you'll receive a notice requesting specific clarifications or corrections within a designated time frame. How will I know my company is officially incorporated? Upon approval, the registrar issues a certificate of incorporation for your company's legal birth certificate. This document includes your unique corporate identity number, SIN official incorporation date, and confirms your entity's legal standing under the Companies Act, authorizing commencement of business activities. What are the fees involved in the incorporation process? Incorporation costs vary based on authorized capital, company type, and jurisdiction. Expenses typically include registration fees, stamp duty, professional service fees, if utilized, and name reservation charges. Some jurisdictions offer discounted rates for online applications or for specific categories, such as startups or small businesses. Can I incorporate my company without professional assistance? Well, self-incorporation is feasible, particularly through streamlined online systems. The process involves complex legal requirements and compliance obligations. Many founders engage legal experts or company secretaries to ensure accurate documentation and efficient regulatory navigation, ultimately reducing risks and preventing potential complications. How long does the entire incorporation process typically take? With properly prepared documentation, the complete process generally requires 5 to 15 business days from submission to certification. Timeframes vary by jurisdiction and application quality. Many regions offer expedited processing options for additional fees, potentially reducing wait times to just 2 to 3 business days. Frequently asked questions about charitable companies. Charitable companies under Section 8 are non-profit entities with limited liability that must direct all profits toward their charitable objectives, rather than distributing them as dividends to members. What are companies with charitable objects? These specialized entities established under Section 8 pursue charitable purposes including the advancement of art, education, sports, science, social welfare, religion, humanitarian efforts, and environmental protection. Can these companies generate profits? Yes. However, all profits must be exclusively dedicated to advancing their charitable mission. They are legally prohibited from distributing any earnings as dividends to their members. Are these companies required to use limited in their name? No. The central government may exempt these organizations from including limited or private limited in their registered names. What unique regulations govern these companies? While enjoying limited liability protection, these entities must follow specific regulations. Most importantly, they must reinvest all profits into their charitable purposes and cannot distribute dividends to members under any circumstances. What tax advantages do charitable companies receive? These entities may qualify for income tax exemptions under Section 12AA of the Income Tax Act. They can also accept tax-deductible donations, offering their donors tax benefits under Section 80G. How does a charitable company differ from a trust or society? Unlike trusts or societies, charitable companies have corporate legal status with limited liability protection and operate under the Companies Act. Though they face stricter compliance requirements, they offer greater structural flexibility and institutional credibility. Can a charitable company later convert to a regular company? Yes, though this conversion requires specific approval from the central government. The company must prove that this transition will not compromise its charitable commitments or the proper use of its existing assets. What consequences might a charitable company face if it violates its nonprofit status? If a company diverts any profits or assets toward non-charitable purposes, the central government may revoke its license. Both the company and its officers may face significant penalties, and the organization risks losing all tax benefits. Effective registration. Registration transforms a company into a distinct legal entity with perpetual existence, conferring specific rights and establishing a corporate identity entirely separate from its individual members. Frequently asked questions about the legal consequences of company registration. What happens when a company gets registered? Upon registration, the company becomes a separate legal entity distinct from its members, effective from the date specified on the registration certificate. This creates the corporate veil, a legal separation between the company's liabilities and those of its shareholders. Does a registered company have an end date? No. Registered companies enjoy perpetual succession. They continue to exist indefinitely regardless of changes in membership, until formally dissolved through legal procedures. The company's existence persists even if all original members depart or pass away. What legal capacities does a registered company possess? A registered company can acquire and dispose of property, enter into contracts, initiate legal proceedings, and be subject to litigation, all in its own name. It can also secure financing, create charges on its assets, and establish various business relationships as an independent legal entity with full contractual capacity. Who constitutes the company after registration? The original signatories of the memorandum during registration, together with all subsequent members, collectively form the company as a body corporate while these individuals comprise its membership. The company exists as a separate legal person with its own rights and obligations. What is the significance of the common seal after registration? The common seal functions as the company's official signature and legal imprimatur, when properly applied to documents in accordance with the Articles of Association. It signifies the company's formal authorization and binding commitment to agreements and legal undertakings. How does registration affect member liability? Registration typically limits members' liability to their unpaid share contributions or guarantees, depending on company type. This limited liability protection represents one of the fundamental advantages of incorporation, shielding personal assets from business liabilities. What are the taxation implications of registration? Following registration, the company becomes an independent tax entity with distinct fiscal responsibilities. It must submit its own tax returns and fulfill corporate tax obligations on profits, entirely separate from the personal tax affairs of its members or shareholders. Common questions about memorandum and articles. The memorandum and articles establish legally binding agreements between a company and its members, creating contractual obligations and operational frameworks as codified in Section 10 of the Companies Act. How do the memorandum and articles affect a company and its members? Upon registration, these documents establish a binding contractual relationship among all involved parties. Both the company and its members become legally bound by all provisions within these documents. They define decision-making protocols, authority structures, and dispute resolution mechanisms. Are financial obligations in these documents legally enforceable? Yes. Any financial contribution specified in the memorandum or articles becomes a legally recoverable debt owed to the company. The company has full legal authority to pursue collection through appropriate judicial channels, similar to enforcing any contractual financial obligation. What legal status does Section 10 of the Companies Act confer on these documents? Section 10 explicitly establishes the binding legal nature of these documents upon registration. It transforms them from draft agreements into enforceable legal instruments that constitute the company's constitutional foundation, governing all internal relationships. Can the memorandum and articles be amended after registration? Yes, through prescribed procedures. Most companies can modify their articles via special resolution, typically requiring 75% shareholder approval. Memorandum amendments may require additional procedures depending on the modification type. All amendments must be properly filed with the Registrar of Companies. What consequences result from non-compliance with these documents? Violations by either members or the company can trigger legal proceedings. Aggrieved parties may seek judicial intervention for enforcement, potentially resulting in court orders, financial penalties, or other appropriate remedies proportionate to the breach. Are these documents subject to public disclosure? Yes. Following registration, both documents become part of the public record. Any interested party may obtain official copies from the Registrar of Companies by paying the stipulated fee. This transparency requirement ensures all stakeholders and potential business partners can access the company's governance framework. Commencement of business. Frequently asked questions prior to initiating operations. Newly incorporated companies must file a director's declaration and verify their registered office address within 180 days of incorporation, or face substantial legal consequences and financial penalties. What prerequisites must a new company fulfill before commencing business? Newly incorporated companies with share capital must submit the following critical documents before commencing business operations or securing any loans. A comprehensive director's declaration confirming all subscribers have paid in full for their allotted shares. Formal verification of the company's registered office address. Official certification that the company has satisfied all statutory incorporation requirements. A formal declaration of intent to commence commercial operations. What is the statutory time frame for filing these documents? The director's declaration must be submitted within 180 days, approximately 6 months, from the date of incorporation. This deadline is stringently enforced under Section 10A of the Companies Act, with no statutory provisions for extensions or grace periods. What are the consequences of non-compliance with these regulations? Non-compliance may result in substantial financial penalties for both the company and its officers. Moreover, the registrar possesses the statutory authority to strike off the company's name from official records if no genuine business activity is detected. Company officers may additionally incur personal liability for corporate debts if operations commence without the requisite documentation, which company official must execute the director's declaration. The declaration requires the signature of a duly appointed director who is explicitly authorized to make such attestations. This director assumes personal legal responsibility and fiduciary duty for the accuracy and veracity of all information provided in the declaration. Is there a prescribed format for submitting the director's declaration? Yes, declarations must be submitted using Form N-20A as specifically prescribed under the Companies Act. This standardized form requires detailed disclosure regarding share payments and must be executed in strict compliance with all statutory requirements. Do any exemptions exist for these compliance requirements? Companies incorporated without share capital are generally exempt from the director's declaration regarding share payments, though they must still register and verify their office location. Certain government companies may operate under modified regulatory frameworks with alternative compliance protocols. Can these statutory documents be filed through digital channels? Yes, the Registrar of Companies fully supports electronic submission of these documents through their official online portal. Digital signatures with appropriate certification are mandatory for such electronic filings to ensure their legal validity, authenticity, and enforceability. Registered office. Common questions. Every company must maintain a registered office as its official address, establish it within 30 days of incorporation, and display proper identification on all business communications. What is a registered office? A registered office serves as your company's official address for receiving legal notices and correspondence. This mandatory address, recorded with the Registrar of Companies, functions as the central point for all official communications. Government agencies, tax authorities, and regulatory bodies direct all correspondence to this location. Your registered office may differ from your operational headquarters while still maintaining its legal status as your company's official address. How soon must I establish a registered office? You must establish a registered office within 30 days of incorporation by filing Form Incorporated 22 with the Registrar of Companies. Any subsequent relocation requires notification to the registrar within 15 days through the appropriate forms. Failure to establish a registered office within the stipulated time frame violates Section 12 of the Companies Act and may incur significant penalties. What information must I display at my office? Your company name and address must be prominently displayed outside your premises in legible letters and in the prevalent local language. For offices in multi-tenant buildings, your company name should appear both at the building entrance and at your specific office location. In multilingual regions, display information in both English and the local language to ensure compliance and maximize visibility. What details should appear on business letters and emails? All business communications must include your company name, registered office address, corporate identity number, SIN, and contact information. Required details also include your company website, if applicable, tax identification numbers such as GST registration, and place of registration. Private limited companies must include private limited after the company name, while public companies must display limited. These requirements apply to all correspondence including letterheads, invoices, and official emails. What are the consequences of non-compliance? Non-compliance with registered office requirements can trigger daily penalties of $1,000 up to a maximum of $100,000. Company officers may face personal liability for these violations. If the registrar determines the company is not operating from its declared address, the company's name may be struck off the register, effectively rendering it defunct. Reinstating a struck-off company involves a costly and time-consuming process. Regular compliance inspections make continuous adherence to these requirements essential. Alteration of memorandum. Common questions. Modifying a company's memorandum requires special resolutions and government approval, particularly for name changes and registered office relocations across state boundaries. Understanding these requirements is essential for proper corporate governance. Key questions about altering a company's memorandum. How can a company change its memorandum? Companies must pass a special resolution following Section 13 procedures, which requires approval from a majority of shareholders. This resolution must be filed with the registrar within 30 days of passage to ensure legal validity and proper documentation. Does changing the company name require approval? Yes, all name changes require written approval from the central government. The only exception applies when adding or removing the word private during company type conversion. The new name becomes officially effective from the date specified in the updated Certificate of Incorporation. What is the process for relocating a registered office to another state? Interstate office relocation requires central government approval through a comprehensive application. Companies must submit Form Incorporated 23 along with detailed supporting documentation that thoroughly justifies the business rationale for the interstate move. What specific requirements apply to Objects Clause modifications? Objects Clause alterations require public notification through a newspaper circulating in the registered office district. Companies must also publish this notice on their website, if applicable, clearly articulating both the nature and strategic reasoning behind the proposed objects modification. Are there strict time frames for implementing memorandum changes? Yes, most alterations must be registered with the registrar within 30 days of approval. Missing this critical deadline can result in substantial penalties and potentially invalidate the legal recognition of these corporate changes. What rights do dissenting shareholders have regarding memorandum alterations? Shareholders opposing fundamental business changes have exit rights that protect their interests. This mechanism entitles dissenting shareholders to have their shares purchased at fair market value, providing important protection for minority stakeholders during significant corporate transformations. Alteration of articles. Frequently asked questions. Modifying a company's articles requires a special resolution with 75% shareholder approval. Public to private conversions necessitate additional government approval, and all amendments must be filed with the registrar within 15 days. These changes can profoundly impact shareholder rights and company operations. Common questions about article alterations. How can a company change its articles? Companies must pass a special resolution in a general meeting, securing approval from 75% of voting shareholders. This requirement applies to all modifications, including conversions between private and public company status. The resolution must explicitly detail all proposed changes. Is any special approval needed for changing from a public to private company? Yes, converting from public to private status requires central government approval. This additional safeguard protects minority shareholders during this significant transition. The approval process demands comprehensive documentation substantiating the conversion rationale. What must a company do after changing its articles? Companies must submit all modifications to the registrar within 15 days, accompanied by a printed copy of the updated articles. Failure to meet this deadline triggers penalties for both the company and its officers. Maintaining meticulous records of this filing is strongly advised. Can article alterations affect existing shareholder rights? Article modifications can impact existing shareholder rights, though they cannot force shareholders to increase their investment without consent. Courts may intervene when changes unfairly disadvantage minority shareholders or alter class rights without following proper procedures. Are there any restrictions on what can be changed in the articles? While companies maintain considerable flexibility in modifying articles, important limitations exist. Changes must comply with Companies Act provisions, adhere to public policy, and remain within legal parameters. Moreover, all modifications must genuinely benefit the company as a whole, not merely specific shareholders. How do article alterations affect existing contracts and agreements? Article modifications do not automatically override existing contracts with third parties or shareholders. The company remains bound by these prior agreements. However, once properly registered, the revised articles will govern all future contracts and internal operations. Common questions about company documents. Members have statutory rights to request company documents, which must be provided within 7 days. Non-compliance results in penalties, with daily fines accumulating up to 100,000 rupees for companies and their officers. Can I obtain copies of my company's essential documents? Yes. As a member, you have the legal right to request copies of the memorandum, articles of association, and other key agreements. The company must provide these within 7 days after payment of a nominal fee. This right is established in Section 17 of the Companies Act and applies to all registered companies. What penalties apply if the company fails to provide requested documents? Companies face substantial financial penalties for non-compliance. A fine of 1,000 rupees applies for each day of delay, with a maximum penalty of 100,000 rupees. Company officers responsible are also personally liable. Persistent violations may trigger additional regulatory scrutiny and sanctions. Why are these constitutional documents documents important. These documents form the foundation of your company's governance structure, defining its operational boundaries and your rights as a member. The memorandum outlines the company's external affairs, while the articles govern internal management and shareholder rights. Access ensures transparency and informed participation. Which specific documents can members request? Members may request a company's memorandum, articles of association, all special resolutions, management appointment agreements, and any document modifying the memorandum or articles. These constitutional documents establish the comprehensive framework for company operations. Must I provide justification when requesting company documents? No justification is required. As a company member, you are entitled to access these documents regardless of your shareholding percentage or membership duration. This right promotes corporate transparency and accountability to all stakeholders. What fees apply to document requests? Fees are typically nominal and designed to cover administrative costs rather than generate revenue. While specific amounts may vary according to company articles or board determinations, they must remain reasonable and cannot be set at levels that would effectively restrict members' access rights. Conversion of companies. Frequently asked questions. Companies can convert to different types through a formal registration process, while maintaining all existing legal obligations, contracts, and agreements without disruption to business continuity. What types of companies can convert to other types? Any registered company can convert to another type by amending its memorandum and articles of association as prescribed under Section 18 of the Companies Act. Common conversions include private to public company transitions for capital raising purposes, public to private company restructuring for streamlined governance, and modifications in limited liability status to adjust risk exposure. The law specifically permits conversion between one-person company structures and private company formations when business scope and operational requirements evolve. How does the conversion process work? The Registrar of Companies terminates the original registration and issues a new certificate reflecting the company's converted classification, while preserving its corporate identity. Companies must submit Form Incorporated 27 accompanied by a special resolution passed by shareholders with the requisite majority, authorizing the conversion. Essential supporting documentation includes the comprehensively amended MOA-AOA, most recent audited financial statements, and the board resolution recommending the conversion with stated justification. Will conversion affect my company's existing agreements? No. All existing debts, liabilities, contractual obligations, and agreements remain fully valid and enforceable after the conversion process without requiring renegotiation or reaffirmation. The company preserves its fundamental legal identity despite the change in its corporate classification, ensuring operational and legal continuity. Any ongoing legal proceedings by or against the company continue uninterrupted following the conversion, with no prejudice to either party's position. Are there any restrictions on company conversion? Yes. Companies with outstanding compliance violations or pending legal prosecutions may face restrictions on conversion eligibility until such matters are resolved. Industry-specific regulatory frameworks may impose additional limitations on conversion options for companies operating in regulated sectors such as banking, insurance, or telecommunications. All companies must satisfy the minimum capital requirements and member shareholder thresholds applicable to their target company classification as stipulated in the Companies Act. Does company conversion affect taxation? The conversion process itself does not constitute a taxable event as the underlying legal identity of the company remains unchanged for fiscal purposes. However, the newly converted company type may become subject to different taxation regimes, compliance obligations, and reporting requirements under applicable tax laws. Professional tax consultation is strongly recommended prior to conversion to fully understand the potential fiscal implications and optimize tax planning strategies. Subsidiary company holdings. Subsidiary companies are prohibited from holding shares in their holding companies, with 3 carefully defined exceptions. Any transfer violating these provisions is automatically void and may trigger severe regulatory consequences. Can a subsidiary company hold shares in its holding company? No. Section 19 explicitly prohibits subsidiary companies from holding shares in their holding companies, whether directly or through nominee arrangements. Any such share transfer is deemed invalid under corporate law. This prohibition encompasses all classes of shares including both equity and preference shares, regardless of the ownership percentage the holding company maintains in the subsidiary. What is the rationale behind this prohibition? This restriction safeguards against circular ownership structures that would fundamentally undermine corporate transparency and accountability. Without this critical protection, companies could engineer artificial capital structures, manipulate market valuations, or systematically bypass corporate governance requirements through strategic cross-holdings. Are there any situations where a subsidiary can hold shares in its holding company? Yes, the law recognizes 3 specific exceptions where a subsidiary may legitimately hold shares in its holding company. When the subsidiary functions as a legal representative for a deceased member of the holding company, thereby facilitating proper estate administration, without necessitating premature liquidation of share positions. When the subsidiary acts as a trustee holding shares, provided that neither the holding company nor its subsidiary maintains any beneficial interest in those shares beyond their fiduciary capacity. When the subsidiary already possessed shares before becoming a subsidiary, however, the subsidiary must typically divest these holdings within 12 months, unless granted an extension by the appropriate regulatory authority. What happens if shares are transferred against these rules? Any share allotment or transfer that contravenes Section 19 is considered void ab initio, rendering the transaction legally null. Furthermore, directors who knowingly authorize such prohibited transfers may face personal liability for regulatory breaches. Companies involved may incur substantial financial penalties, and regulatory sanctions. Shareholders may establish grounds for derivative legal actions against the board of directors. How does this affect corporate group restructuring? During corporate restructuring or acquisition planning, organizations must conduct meticulous evaluation of existing shareholding arrangements. Comprehensive pre-acquisition due diligence should identify and address any potential circular holdings that would violate Section 19. Ensuring these compliance issues are definitively resolved prior to transaction completion. Common questions about document service. Document service to companies requires delivery to the registered office address, while service to registrars or members offers various delivery methods including postal and electronic transmission, each with specific legal implications. How can documents be served to a company? Documents must be delivered to the company's registered office through regular post, speed post, courier service, or in-person delivery. Electronic submission is also acceptable when properly addressed. Section 20 of the Companies Act specifically mandates that all documents be delivered to the official registered address on file with the registrar, not to branch offices or alternative locations. For electronic service, companies must maintain an official designated email address. When documents have legal significance, obtaining proof of delivery is recommended, making registered mail or delivery confirmation services advisable to establish a verifiable record of receipt. How can documents be served to the registrar or company members? Documents may be served via regular post, registered post, speed post, or courier service. In-person delivery to the designated office or address is permitted, as is electronic transmission where appropriate. Company members may request specific delivery methods by paying the applicable fee established by the company. When serving documents to the registrar, submissions must use the official forms prescribed under the Companies Act and rules. The registrar retains the authority to reject documents that fail to meet proper formatting requirements or are substantively incomplete. What constitutes proper service of documents? Proper service occurs when documents are delivered through authorized channels to the correct legal address. For postal delivery, service is generally considered complete when the document is properly addressed, postage is prepaid, and the item is deposited with postal authorities. For electronic delivery, service is deemed complete when the document leaves the sender's information system and enters the recipient's designated system. Are there any time limitations for document service? Yes, the Companies Act establishes specific time frames within which certain statutory documents must be served. Failing to meet these prescribed deadlines may result in monetary penalties or other regulatory consequences. Additionally, companies have a responsibility to acknowledge receipt of properly served documents within a reasonable time frame, as determined by standard business practices and applicable regulations. Authentication of documents. Essential information about how company documents are legally validated. Document authentication requires authorized signatories, typically board-approved individuals, to validate official company papers, establishing their legal validity for business transactions and corporate governance in compliance with regulatory requirements. Who can sign company documents? Board authorized personnel including the managing director, CEO, company secretary, and designated department heads may sign documents on the company's behalf. Section 21. Only individuals with explicit authorization can create legally binding signatures. What documents require authentication? Critical company papers requiring proper authentication include corporate proceedings, contracts, financial statements, regulatory filings, board resolutions, shareholder agreements, and legal instruments executed by or on behalf of the company. Why is authentication essential? Proper authentication ensures documents are legally valid and enforceable. It safeguards against fraud, establishes clear accountability, and provides conclusive evidence of the company's intentions during legal proceedings. Do all employees have signing authority? No, only individuals explicitly authorized by the board may sign official company documents. The board designates specific signatories through formal resolutions that clearly define authority limits and document categories. What are the consequences of improper authentication? Improperly authenticated documents may be deemed invalid, potentially resulting in voided transactions, regulatory penalties, contract disputes, or legal challenges questioning the document's enforceability. Can authentication requirements vary by document type? Yes, authentication protocols differ based on document category. Some require multiple signatories, witness attestations, notarization, or specialized seals depending on legal requirements and the document's importance. How does electronic authentication work? Companies can implement secure digital signature systems with robust authorization controls. Electronic signatures are legally recognized when using approved technologies that verify signer identity and maintain document integrity in accordance with applicable electronic transaction laws. Common questions about bills of exchange. Bills of exchange can be executed by authorized company representatives without requiring a corporate seal. These properly authorized signatures legally bind the company as effectively as if the company itself had executed the document. Who can sign bills of exchange for a company? Any properly authorized individual can execute bills, hundis, or promissory notes on the company's behalf. Their signature creates a legally binding obligation for the company as if it had directly executed the document. This authority typically derives from board resolutions or provisions in the company's articles of association. Does a company need a special seal for document execution? No. In the absence of a common seal, 2 directors or 1 director and the company secretary can authorize an individual to execute documents. This provision facilitates efficient business operations while reducing administrative complexity. Can a company appoint someone to execute legal documents on its behalf? Yes. A company can confer power of attorney to an individual for document execution. This delegation must be properly formalized through specific legal procedures to ensure its validity and enforceability. What does Section 22 mean in practical terms? Section 22 establishes that when an authorized representative executes financial instruments for a company, the law recognizes these signatures as the company's own. This provision acknowledges that companies, being juridical entities, must necessarily act through human representatives. What are the consequences if an unauthorized person signs a bill of exchange? If an individual without proper authorization executes a document on a company's behalf, the company may not be legally bound by it. However, the unauthorized signatory may incur personal liability. Companies should maintain comprehensive authorization records to prevent such complications. Are there specific formalities required for executing bills of exchange? While formal requirements are minimal, signatures must explicitly indicate they're made on the company's behalf. Best practice includes documenting the company name, the signatory's name, and their official position, maintaining consistency across all corporate documents. Are electronic signatures valid for bills of exchange? Most modern jurisdictions now recognize electronic signatures for bills of exchange, provided they satisfy security and authenticity requirements. Companies should verify their jurisdiction's specific legal provisions before implementing electronic signature protocols. Chapter 3. Prospectus and Allotment of Securities. This chapter establishes the regulatory framework for securities offerings, detailing prospectus requirements for public offers, investor protection mechanisms, and alternative capital raising methods through private placements. Frequently asked questions. What is a public offer? A public offer occurs when a company offers securities to the general public. Companies must issue a prospectus disclosing essential information about their financial position, business operations, management qualifications, and specific terms of the offered securities, enabling potential investors to make informed decisions. How does the law protect investors? Investor protection comes through mandatory disclosure requirements, truthful representation of business operations and risks, civil and criminal liabilities for misrepresentations, regulatory pre-approval processes for securities offerings, and ongoing disclosure obligations for public companies. What is private placement? Private placement involves offering securities to a limited group of sophisticated investors rather than the general public. While less stringent than public offerings, companies must still restrict offerings to qualified institutional buyers or a capped number of persons, maintaining specific compliance standards. What is a prospectus? A prospectus is a legal document providing comprehensive information about a public investment offering, including material facts, risk factors, corporate history, audited financial statements, and complete details about the securities being offered, for all essential for informed investment decisions. What are red herring prospectus and shelf prospectus? A red herring prospectus serves as a preliminary document during IPO marketing without specifying price or share quantity. A shelf prospectus allows qualified companies to issue securities over time without filing separate prospectuses for each offering, streamlining capital raising. What happens if a company doesn't comply with prospectus requirements? Non-compliance can result in financial penalties, regulatory enforcement, investor litigation, and potential criminal prosecution of directors and officers. Additionally, companies may be required to refund all investor contributions with interest. These regulatory frameworks maintain market integrity and fairness. By establishing transparency and accountability standards, they build investor confidence and facilitate the efficient allocation of financial resources to productive enterprises, supporting broader economic growth and development. Common questions about securities issuance. Companies can issue securities through various mechanisms depending on their classification as public or private entities, as regulated under Section 23. These frameworks ensure regulatory compliance while providing strategic flexibility for capital raising initiatives. What ways can public companies issue securities? Public companies can issue securities through three distinct channels: public offerings requiring a prospectus, private placements to qualified investors, or rights bonus issues to existing shareholders. Each pathway entails specific regulatory requirements and disclosure obligations that must be rigorously satisfied. How can private companies issue securities? Private companies have two primary avenues for securities issuance: rights or bonus issues to existing shareholders, and private placements to select investors. These options are more constrained compared to public companies due to regulatory restrictions on public solicitation of investments. What does the term public offer encompass? A public offer includes initial public offerings (IPOs) for first-time issuers, further public offerings (FPOs) for subsequent capital raises, or offers for sale of securities to the public via a prospectus. Each category necessitates comprehensive disclosure documentation and regulatory approvals prior to execution. What is Section 23 about? Section 23 establishes the legal framework governing how companies can issue securities based on their classification as public or private entities. It outlines the comprehensive regulatory structure overseeing the issuance process to ensure compliance with standards designed to safeguard market integrity. What is the difference between rights issue and bonus issue? A rights issue allows existing shareholders to purchase additional shares at a preferential price proportionate to their current holdings. Conversely, a bonus issue involves distributing complementary additional shares to existing shareholders based on their current ownership ratio, without requiring any financial contribution. What are the key requirements for private placement? Private placement requires that securities be offered exclusively to a select group not exceeding 200 persons in a financial year, excluding qualified institutional buyers and employees. It also mandates a special resolution by shareholders, specific disclosures in offer documents, and completion of allotment within a strict 60-day time frame from receipt of application funds. How does securities issuance regulation protect investors? Securities issuance regulations protect investors by ensuring transparent disclosure of material information, establishing standardized issuance protocols, preventing fraudulent activities, and preserving market integrity. These safeguards are essential for fostering investor confidence and facilitating efficient capital formation in securities markets.
SEBI's regulatory powers. SEBI possesses comprehensive authority to regulate securities issuance, transfer, and related matters for listed companies and those seeking listing, with powers established under the SEBI Act of 1992. These extensive capabilities enable SEBI to safeguard market integrity and protect investor interests through robust regulatory frameworks and vigilant enforcement mechanisms. What is SEBI's main regulatory authority? Section 24 empowers SEBI to regulate all securities-related matters, including issuance, transfer processes, and dividends non-payment by listed entities. SEBI issues binding directives, comprehensive guidelines, and regulatory circulars to ensure strict compliance with securities laws across the market ecosystem. What specific powers does SEBI have? SEBI exercises powers conferred by the Securities and Exchange Board of India Act, 1992. While SEBI oversees securities-related matters, other issues remain under the jurisdiction of the central government, tribunal, or registrar. SEBI's regulatory toolkit includes conducting thorough investigations, imposing substantial penalties, suspending trading activities, and scrutinizing offer documents like prospectuses and information memoranda. Which companies does SEBI regulate? SEBI's oversight extends to companies currently listed on stock exchanges and those planning future securities listings. Additionally, SEBI regulates all market intermediaries including stockbrokers, merchant bankers, underwriters, and various other participants essential to maintaining market integrity and efficiency. Why is SEBI's regulation important? SEBI's regulatory framework serves as the cornerstone for investor protection and ensures fair, transparent, and efficient securities markets. It effectively prevents unfair trade practices, market manipulation, and insider trading while simultaneously fostering market development, innovation, and cultivating robust investor confidence. How has SEBI's regulatory scope evolved? Since its establishment as a non-statutory body in 1988 and subsequent statutory empowerment in 1992, SEBI's regulatory purview has expanded significantly. Its jurisdiction now encompasses the regulation of mutual funds, foreign portfolio investors, alternative investment funds, and vital market infrastructure institutions including clearing corporations and depositories. What enforcement mechanisms does SEBI use? SEBI deploys a sophisticated array of enforcement tools including formal adjudication proceedings, consent settlements, administrative warnings, and criminal prosecution referrals. Its enforcement actions range from imposing substantial monetary penalties and issuing cease and desist orders to suspending market participant registrations and prohibiting individuals or entities from accessing the securities market. Commonly asked questions about deemed prospectus. A deemed prospectus is a document used for distributing securities that is legally treated as an official prospectus, subject to identical regulatory requirements and scrutiny, with specific statutory criteria determining its classification as a public offering. What is a deemed prospectus? When a company distributes securities with the intention of eventual public sale, any documents facilitating this offer is legally treated as if it were a prospectus issued by the company itself. This principle, codified in Section 25 of the Companies Act, ensures transparency in indirect securities offerings by closing potential disclosure loopholes. What rules apply to a deemed prospectus? All regulatory requirements governing standard prospectuses fully extend to deemed prospectuses. This includes mandatory disclosure requirements and liability provisions for misrepresentations. Directors, promoters, and expert contributors may be held legally accountable for material misstatements or omissions of significant facts that could influence investment decisions. How do we determine if securities were intended for public offering? Securities are legally presumed to be intended for public offering if they are offered to the public within 6 months after initial distribution, or if the company has not received complete payment at the time the offer is made. This temporal threshold prevents circumvention of disclosure requirements through strategic phased distribution approaches. What is the purpose of deeming certain documents as prospectuses? This provision prevents regulatory arbitrage where companies might attempt to bypass prospectus requirements through intermediaries or alternative documentation. It ensures investors receive standardized, comprehensive disclosure regardless of offering offering structure, thereby maintaining market integrity and strengthening investor protection mechanisms. Who bears liability for misstatements in a deemed prospectus? As with standard prospectuses, all parties who authorized the issuance of the document containing the sale offer bear potential liability. Additionally, the company whose securities are being offered and its directors at the time of issuance may face legal consequences for any misleading or inaccurate information that could materially impact investor decisions. Are there any exemptions from deemed prospectus requirements? Yes. Certain qualified private placements and offerings exclusively to sophisticated institutional investors may qualify for exemptions under specific regulatory conditions. However, these exemptions are narrowly defined and strictly interpreted, and companies should obtain comprehensive legal counsel to ensure full compliance with all applicable securities regulations. Common questions about prospectus requirements. A prospectus must contain comprehensive financial information, include mandatory regulatory declarations, and be properly filed with the registrar bearing all directors' signatures before publication to ensure investor protection and market transparency. What information must be included in a prospectus? Every prospectus must contain detailed financial information and reports as mandated by SEBI and the central government. Section 26 of the Companies Act explicitly outlines these disclosure requirements. The document must comprehensively detail the company's incorporation history, capital structure, and current operations. Transparent disclosure of the company's promoters, their professional background, and shareholding patterns is mandatory. All investment risk factors must be clearly identified and explained in plain language. Full disclosure of outstanding litigations and material developments that could impact company performance is required. Does a prospectus need to include any declarations? Yes. The prospectus must include a formal statement confirming compliance with all regulations in the Companies Act, Securities Contracts Act, and SEBI Act. All directors must provide explicit declarations accepting responsibility for the information's accuracy and completeness. The company's auditors must furnish a formal declaration verifying the financial statement's accuracy. Where applicable, a declaration confirming compliance with industry-specific regulations is necessary. A clear statement regarding all governmental or regulatory approvals obtained must be included when relevant. What is the filing process for a prospectus? Before publication, a complete copy of the prospectus must be filed with the Registrar of Companies. All current directors and proposed directors must personally sign this copy, validating its contents. Written consent from all experts cited or quoted in the document must accompany the submission. All material contracts referenced must be attached as supporting documentation. The prospectus must bear a specific date, legally recognized as the official publication date. Following registrar submission, a copy must be provided to SEBI for thorough regulatory review. The public offering may proceed only after securing all necessary regulatory approvals. Variation in terms of contract or objects. When companies seek to modify terms stated in their prospectus, they must adhere to strict procedures, offer exit options to dissenting shareholders, and refrain from using raised funds to acquire shares in other companies. These robust safeguards ensure transparency and protect investor interests throughout any modifications to the original offering terms. Key points about variations in prospectus terms. What approvals are needed to change contract terms mentioned in a prospectus? Companies must secure approval through a special resolution to modify any contract terms or objects stated in their prospectus. These changes must be advertised in newspapers, one English national daily and one in the regional language where the registered office is located, with a clear rationale. The board of directors must provide comprehensive justification in their reports to shareholders. What legal provisions govern these variations? Section 27 of the Companies Act specifically regulates variations to contract terms or objects in the prospectus. These provisions prevent companies from unilaterally changing the purpose for which they solicited public funds. What happens if shareholders disagree with the changes? Dissenting shareholders must be provided an exit opportunity, where promoters or controlling shareholders offer to repurchase their shares at a fair value determined by SEBI. This exit option must be advertised alongside the special resolution notice. Shareholders must formally register their objection within the stipulated time frame. What is the procedure for implementing the exit option? The company must appoint a qualified merchant banker to determine fair share value and manage the exit process. All expenses related to this exit option must be borne by the promoters or controlling shareholders, not by the company itself. Can companies use money raised through a prospectus to buy shares in other companies? No. Companies are strictly prohibited from using funds raised through a prospectus to purchase, trade, or otherwise deal in equity shares of any other listed company. This restriction prevents diversion of funds from stated objectives and protects investor interests. Violations attract penalties under the Companies Act. Are there any exceptions to these restrictions? The only exception applies to companies whose primary business involves securities investment. In such cases, the prospectus must explicitly disclose the investment strategy and comprehensively outline all associated risk factors. These regulatory provisions collectively ensure that investor funds are deployed precisely for the purposes outlined in the prospectus, and that any subsequent modifications provide adequate protection to investors who may oppose such changes. Frequently asked questions. Offer of sale by members. Company members can offer their shares for public sale through a structured process involving the board of directors. This transaction requires a prospectus equivalent document, with the company facilitating the sale on behalf of members while being fully reimbursed for all associated expenses. Key questions about how company members can offer their shares to the public. How can company members sell their shares to the public? Members may offer their shares through a collaborative process with the company's board of directors as permitted under Section 28 of the Companies Act. The board must formally approve the offer and ensure complete compliance with all applicable regulatory requirements before proceeding. What documentation is required when members sell shares? The offer document is legally treated as a company-issued prospectus and must fulfill all disclosure requirements. This includes detailed financial information, risk factors, company background, and specific characteristics of the shares being offered. What is a company's role when members sell shares? The company serves as an authorized representative for the offering members. These members must provide explicit authorization to the company and fully reimburse all expenses incurred during the sale process. While ensuring regulatory compliance, the company bears no financial responsibility for the offer itself. Which members face restrictions when selling shares? Promoters, directors, and company insiders typically face specific restrictions and mandatory lock-in periods before they can sell their shares. These regulatory safeguards protect market integrity and prevent potential insider trading or market manipulation. What must members disclose when selling shares? Members must disclose all material information that could influence an investor's purchase decision. This includes comprehensive details about the selling rationale, pricing methodology, any special rights attached to the shares, and potential conflicts of interest. How is the share price determined for member-sold shares? Share pricing can be established through various SEBI-approved methodologies, including book building, fixed price mechanisms, or other validated valuation approaches. The pricing process must be fair, transparent, and clearly documented in the offer document with complete methodological explanations. What are the consequences of misstatements in the offer document? Similar to company prospectuses, members and directors may face liability for material misstatements or significant omissions in the offer document. Consequences can include substantial financial penalties, regulatory sanctions, and in cases of deliberate fraud, criminal prosecution. Dematerialization of securities. Common questions. Dematerialization converts physical share certificates into electronic form, enhancing security and trading efficiency. Public companies must issue securities electronically, while designated unlisted companies can only transfer securities in dematerialized form to maintain regulatory compliance. Here are answers to common questions about dematerialization. What is dematerialization of securities? Dematerialization transforms physical share certificates into electronic records stored in a demat account. This eliminates risks associated with physical handling and streamlines securities management across the financial ecosystem. Which companies must issue securities only in electronic form? Companies making public offerings and other specifically designated companies must issue securities exclusively in electronic form, as mandated by Section 29 in the Depositories Act, 1996. This requirement applies to all new security issuances after the regulation's implementation date. What about unlisted companies? Certain unlisted companies, as specified by regulations, must hold and transfer securities only in electronic form according to the Depositories Act, 1996. These requirements enhance market transparency and operational efficiency in securities transactions. Can any companies still use physical share certificates? Yes. Companies not covered by dematerialization regulations may continue issuing physical securities or voluntarily convert to electronic form. However, the market is progressively moving toward complete dematerialization as a standard practice. Why is dematerialization important? Electronic securities provide enhanced safety, eliminate risks of damage or theft, facilitate faster transfers, reduce administrative paperwork, improve record-keeping accuracy, and simplify corporate actions such as dividend distributions and rights issues. What is the process for dematerializing existing physical certificates? Shareholders must open a demat account with a depository participant, DP, submit a completed dematerialization request form, DRF, and surrender their physical certificates. The DP then facilitates the conversion through the appropriate depository system. Who are the major depositories in India? The National Securities Depository Limited, NSDL, and Central Depository Services Limited, CDSL, function as India's primary depositories, providing the essential infrastructure that supports the entire dematerialization ecosystem. Are there any fees involved in dematerialization? Yes. Fees typically include charges for opening and maintaining a demat account, plus transaction costs for converting securities. Fee structures vary among depository participants based on their service offerings. Can dematerialized securities be converted back to physical form? Yes. Through dematerialization, investors can convert electronic holdings back to physical certificates, though this practice is increasingly uncommon and generally discouraged given the substantial benefits of maintaining electronic holdings. How does dematerialization affect corporate actions like dividends and bonuses? Corporate benefits including dividends, bonuses, and rights issues are credited directly to investors' demat accounts, eliminating processing delays and substantially reducing the risk of loss associated with physical certificate management. Advertisement of prospectus. Section 30 requires prospectus advertisements to include specific company information, ensuring transparency for potential investors. These advertisements serve as concise summaries of the full prospectus and must adhere to strict regulatory standards. What must be included in a prospectus advertisement? Under Section 30, prospectus advertisements must clearly state the company's objectives, member liabilities, and share capital structure in accessible language. The advertisement must articulate the company's core business purpose and explicitly indicate whether shareholder liability is limited or unlimited. Advertisements should avoid technical jargon that might confuse investors, instead presenting information in a clear, straightforward format that enables informed decision-making. What other details are required in the advertisement? The advertisement must disclose the names of signatories to the company's memorandum, their share subscriptions, and the full structure of the company's capital. This includes details about various share classes offered, their associated voting rights, and any dividend preferences. Additionally, the advertisement must prominently display the company's registered office location, contact information, and instructions for obtaining the complete prospectus document. Why are these advertisements regulated? These regulations ensure potential investors receive accurate, clear information before committing capital, facilitating more informed investment decisions. By standardizing prospectus advertisements, regulators help prevent misleading claims and safeguard investors against fraud or misrepresentation. Such transparency requirements strengthen market integrity and build investor confidence in the securities market. Companies also benefit as these regulations establish credibility and trust with prospective investors from the outset. Who needs to follow these advertisement rules? All companies issuing prospectus advertisements must comply with these requirements, regardless of size or industry. This applies to both public and private companies seeking capital through public offerings. Financial intermediaries distributing these advertisements on behalf of companies must also ensure full compliance with Section 30. Non-compliance may result in penalties, legal proceedings, or regulatory investigations that could damage company reputation and disrupt the offering process. What is the relationship between the advertisement and the full prospectus? The advertisement functions as a precise preview of the full prospectus. While it must contain all essential information required by Section 30, it should clearly direct potential investors to where they can access the complete prospectus for comprehensive details. Companies must maintain complete consistency between advertisements and the full prospectus to avoid allegations of misleading investors. No material information in the prospectus should be contradicted or misrepresented in the advertisement. Shelf prospectus. A shelf prospectus enables qualified companies to issue securities multiple times within a year without filing new prospectuses, streamlining capital raising while protecting investors through information memorandums for subsequent offerings. Key aspects of shelf prospectus is explained in clear terms. What is a shelf prospectus? This specialized document under Section 31 remains valid for 1 year, allowing eligible companies to offer securities multiple times without creating a new prospectus for each issuance. This significantly expedites the fundraising process for qualified entities. Who can use a shelf prospectus? This option is available exclusively to organizations that meet Section 31 requirements, including public financial institutions, public sector banks, scheduled banks, and companies satisfying SEBI's specific criteria for track record, financial stability, and regulatory compliance. What are the key benefits? Companies gain strategic flexibility in market timing, reduce documentation and administrative costs, faster access to capital markets during favorable conditions, and the ability to capitalize on funding opportunities without delays associated with creating entirely new prospectuses. What happens with subsequent offerings? For additional offerings within the 1-year validity period, companies must file an information memorandum detailing significant changes since the original shelf prospectus filing. This ensures investors receive current information while eliminating redundant disclosures. What must be disclosed in the information memorandum? Companies must report newly created financial charges, material changes in financial position, significant regulatory actions or legal proceedings, developments affecting business operations, other legally mandated disclosures. How does this work legally? The original shelf prospectus combined with the updated information memorandum constitutes a complete prospectus for regulatory purposes. This comprehensive package fulfills all disclosure requirements while streamlining the offering process. Are there limitations? Yes. The 1-year validity period represents a key constraint. Additionally, companies remain subject to all other securities regulations, and SEBI maintains authority to require supplementary disclosures when circumstances warrant. How does this differ from a traditional prospectus? While a traditional prospectus serves a single securities offering, a shelf prospectus establishes a framework for multiple offerings throughout its validity period, substantially reducing regulatory burden for subsequent issuances while maintaining robust investor protections. The shelf prospectus mechanism represents an effective regulatory solution that balances efficient capital raising for established companies with comprehensive investor protections through targeted, ongoing disclosure requirements. Red herring prospectus. Common questions. A red herring prospectus serves as a preliminary document filed before securities offerings, deliberately omitting final price and quantity details. Companies must file it at least 3 days before opening subscriptions and follow with a complete prospectus after the offering concludes. What is a red herring prospectus? It's a preliminary document issued before the final prospectus when planning securities offerings. While comprehensive in most aspects, it strategically omits specific offering size and pricing details. This document gauges investor interest while preserving flexibility for final terms. Why is it called a red herring prospectus? The name comes from the prominent disclaimer printed in red ink on the cover page, alerting investors that the document is preliminary and subject to change. This distinctive red warning clearly indicates that certain critical details remain unfinalized. What information does it contain? Though lacking final pricing and quantity details, it provides comprehensive information including company background, financial statements, business model analysis, risk factors, intended use of proceeds, and management profiles for all essential for informed investment decisions. What information is typically omitted? The final offering price, exact number of securities to be issued, and precise issuance date are intentionally excluded. These elements are determined after assessing market demand during the pre-marketing phase. When must a company file this document? Companies must submit the red herring prospectus to the registrar at least 3 days before the subscription period opens. Any material differences between this preliminary document and the final prospectus must be clearly highlighted. Is investor money collected at this stage? Yes. Companies may collect subscription funds based on the red herring prospectus, provided they clearly specify the price band within which the final price will be set. This defined range helps investors evaluate the potential investment opportunity. What happens after the offering closes? Upon offering completion, the company must file a final prospectus disclosing the total capital raised, the final security price, and any other previously omitted material information. This final prospectus must be filed with both the registrar and SEBI. Can a company withdraw the offer after issuing a red herring? Yes. Companies retain the right to cancel a securities issue even after filing a red herring prospectus, typically in response to unfavorable market conditions or insufficient investor interest. In such cases, they must promptly refund all subscription amounts. What are the legal implications of a red herring prospectus? Despite its preliminary nature, a red herring prospectus carries full legal weight. Companies bear complete liability for misleading statements or material omissions. Just as with a final prospectus, investors who suffer losses due to misrepresentations have grounds for legal recourse. Frequently asked questions about security applications. Security applications require an abridged prospectus, with investors retaining the right to request the full document. Non-compliance incurs a $50,000 fine per violation. These regulations ensure transparency and protect investor interests through comprehensive disclosure requirements. Do I need anything with my application form? Yes. Your application form must include an abridged prospectus for a condensed version of the full document containing all essential information in a streamlined format. This requirement doesn't apply to underwriters or when securities aren't offered to the public. Can I see the full prospectus before I invest? Absolutely. You're entitled to request and receive the complete prospectus anytime before the application closing date. Companies must fulfill this request by law, ensuring you have access to comprehensive information on risk factors, financial statements, and management details before committing to your investment. What happens if companies don't follow these rules? Companies face a $50,000 fine for each violation. Persistent non-compliance may trigger additional regulatory scrutiny and legal consequences. Authorities strictly enforce these rules as they directly safeguard market transparency and investor protection. Who is responsible for ensuring the abridged prospectus is accurate? The company's directors and promoters bear primary responsibility for the accuracy of all information. They must conduct thorough due diligence to verify all statements are factual and that no material information has been omitted from either the abridged or full prospectus. How does the abridged prospectus differ from the full prospectus? The abridged prospectus presents the same essential information in a more concise format. It includes key details about the issue, risk factors, company financials, and offering objectives, while omitting elaborate explanations and supporting documentation found in the complete version. Are electronic copies of the prospectus acceptable? Yes. Companies may provide electronic copies of both versions, provided they comply with electronic delivery regulations. Investors can specify their preference for physical or digital formats, though companies must ensure the electronic version exactly matches the printed document in content and presentation. Common questions about criminal liability. Criminal liability arises when false or misleading information appears in a prospectus, potentially resulting in fraud charges. Responsible parties face significant penalties, though valid defenses exist if the information wasn't material or if there was reasonable belief in its accuracy. What happens if someone includes false information in a prospectus? Under Section 34, any person who authorizes a prospectus containing untrue or misleading statements may face fraud charges. Section 447. This serious offense carries imprisonment from 6 months to 10 years and fines ranging from the fraud amount up to 3 times that value, reflecting the gravity of misrepresenting investment opportunities. Can someone be held responsible for information that was left out? Yes. Omitting material information that could mislead investors carries the same legal weight as making false statements. The legal system treats such omissions as equally serious violations when they significantly impact investor decision-making. Courts specifically assess whether the omission would have altered a reasonable investor's investment decisions. How can someone defend themselves against these charges? They may establish a defense by proving that the misstatement or omission wasn't material to investor decisions. They had genuine, reasonable belief in the information's accuracy when the prospectus was issued. They conducted appropriate due diligence before approving the prospectus. They reasonably relied on credible expert opinions available at that time. Who typically faces these charges? Those commonly liable include directors who authorized the prospectus, company officers overseeing its preparation, underwriters involved in drafting or reviewing the document, professional experts, accountants, lawyers, etc., who contributed specialized content or verification. What's the difference between civil and criminal liability in these cases? Civil liability focuses on investor compensation for financial losses, while criminal liability aims to punish deliberate wrongdoing. Criminal cases require proving guilt beyond reasonable doubt and typically involve intentional deception or fraud rather than mere negligence, resulting in personal penalties rather than just financial remedies. Can insurance protect against criminal liability? No. While directors and officers, D&O, insurance may cover civil liabilities and legal defense costs, it cannot shield individuals from criminal penalties such as fines or imprisonment when fraud is established. Insurance policies specifically exclude coverage for intentional misconduct, leaving individuals personally exposed to criminal sanctions. Civil liability for misstatements. Directors, promoters, and experts who approve a prospectus face significant liability for misleading statements, with several legal defenses available. In cases of fraud, unlimited personal liability applies regardless of corporate protection. Understanding these potential consequences is essential for anyone involved in securities issuance. Who can be held liable for misleading statements in a prospectus? The following parties may be required to compensate investors who suffered losses due to misleading statements or material omissions. Company directors at the time of prospectus issuance. Individuals who consented to be named as directors or were designated as future directors. Company promoters involved in the formation or promotion process. Any person who authorized or approved the prospectus contents. Experts, such as accountants, valuers, or engineers, whose professional opinions appear in the prospectus. Any individual who authorized the prospectus issuance. How can someone defend against this liability? A person may avoid liability by establishing any of these legal defenses. They withdrew consent before prospectus issuance, and it was published without their authorization. The prospectus was released without their knowledge or consent, and they promptly issued reasonable public notice upon discovery for expert statements. They had reasonable grounds to believe the expert was competent and had consented to the inclusion of their statement. They conducted thorough due diligence and had reasonable basis to believe the statements were accurate when issued. The plaintiff acquired securities with prior knowledge of the statement's falsity. What is the extent of civil liability? Liability typically encompasses compensation for investor losses directly attributable to reliance on the misleading statements. This generally involves reimbursing the investment amount minus any returns already received or the security's current market value. What happens in cases of fraud? If an individual deliberately included false statements or omitted material facts with intent to deceive, they will face unlimited personal liability for compensation with no financial cap, nullification of any indemnity clauses in company documents that might otherwise protect them, potential additional punitive damages beyond direct compensation, exclusion from company insurance coverage that would normally protect against unintentional misstatements. What is the time limit for bringing civil liability claims? Investors must file claims within a specific time frame after discovering the misstatement or omission, typically 1-3 years depending on jurisdiction. Most legal systems also impose an absolute limitation period, usually 5-10 years, from the date of prospectus issuance, regardless of when the issue was discovered. How does this liability differ from criminal liability? Civil liability focuses primarily on providing financial compensation to affected investors, while criminal liability involves punitive measures such as fines and imprisonment. Criminal proceedings require proof beyond reasonable doubt, whereas civil cases are decided on the lower balance of probabilities standard of evidence. Common questions. Fraudulent investment inducement. Section 36 prohibits knowingly making false statements or concealing material facts to induce investments, securities transactions, or loans. Violations constitute fraud under Section 447 and carry severe penalties. What is fraudulent investment inducement? Fraudulent investment inducement occurs when someone deliberately provides false information or withholds crucial facts to mislead others into investing funds, trading securities, or obtaining financial loans. This deception may include fabricating business projections, misrepresenting financial health, or omitting critical risk information that would significantly alter investment decisions. What actions are prohibited under Section 36? The following actions are explicitly prohibited: making false statements to induce securities purchases, sales, or subscriptions, deceiving others into agreements based on securities value fluctuations, misrepresenting information to secure loans from banks or financial institutions, enticing participation in investment schemes through false information, facilitating fund transfers based on misrepresented business opportunities. What penalties apply for violations? Violations are punishable under Section 447 for fraud, with penalties designed to protect market integrity including imprisonment ranging from 6 months to 10 years, financial penalties up to 3 times the fraud amount, mandatory disgorgement of all illicitly obtained assets, potential permanent disqualification from company directorship who receives protection under this provision. This provision safeguards various market participants against deceptive practices involving false statements or material omissions, including retail investors making personal investment decisions, institutional investors and investment funds, financial institutions providing loans and banking services, commercial entities entering financial arrangements. What are common examples of fraudulent inducement? Typical Section 36 violations include presenting manipulated financial statements to suggest false profitability, deliberately concealing significant corporate liabilities or debts, misrepresenting management team qualifications or expertise, creating fictitious customer testimonials or business relationships, promoting guaranteed returns for inherently high-risk investments. How can investors protect themselves? Prudent investors should take these protective measures: verify company information through independent, authoritative sources, thoroughly examine prospectuses and all disclosure documentation, research the background and track record of company leadership, remain skeptical of investments promising unusually high returns, consult qualified, independent financial advisors before significant commitments. Action by affected persons. Section 37 grants legal rights to individuals and groups who suffer losses due to false information in a prospectus, allowing them to seek compensation through legal action. What can I do if a prospectus contains false information? Under Section 37, if you suffer financial losses resulting from misleading statements or material omissions in a prospectus, you have the right to initiate legal proceedings to recover damages. The legislation recognizes investors' substantial reliance on prospectus information for investment decisions and provides comprehensive remedies when that information proves inaccurate or misleading. Who can take legal action? Any person or entity that incurred financial losses due to false prospectus information has legal standing to pursue remedies. This encompasses individual retail investors, institutional investors, mutual funds, pension funds, and all other parties whose investment decisions were materially influenced by the misleading document. Which sections enable my legal recourse? You may pursue compensation under Sections 34, 35, or 36. Section 34 addresses criminal liability for prospectus misstatements. Section 35 covers civil liability for prospectus misrepresentations. Section 36 pertains to fraudulent inducement to invest. What compensation am I entitled to seek? Potential remedies include complete recovery of your initial investment amount, compensation for all direct financial losses incurred, statutory interest on losses where applicable, reimbursement of legal expenses in qualifying circumstances. Is there a time limit for taking legal action? Yes. Strict statutory limitations apply to these claims. Consult a qualified legal professional immediately upon discovering any misrepresentation to safeguard your right to compensation before the limitation period expires. Why is this provision significant? This provision protects investor interests by establishing a clear pathway to compensation when financial losses occur due to prospectus misrepresentations. Furthermore, it functions as a powerful deterrent, compelling companies and their officers to ensure all prospectus information remains accurate, comprehensive, and transparent. Do I need to prove intent to mislead? Not in all cases. Liability may attach even without evidence of deliberate deception. Demonstrating negligence in information disclosure can constitute sufficient grounds for a successful claim under specific statutory provisions. Common questions about fake identities in buying shares. Section 38 prohibits the use of fictitious names when applying for shares and empowers courts to confiscate profits and redirect funds to investor protection programs. What does Section 38 say about using fake identities? Section 38 establishes clear penalties for fraudulent activities, including applying for or purchasing shares using fictitious names, submitting multiple applications under different identities to increase allocation chances, deliberately inducing companies to allocate shares to non-existent persons, using aliases or falsified information on official application documents, establishing fictitious entities or shell companies specifically to acquire shares. This provision was enacted to prevent market manipulation and ensure equitable distribution of securities during initial public offerings, IPOs, and subsequent share issuances. What are the consequences for using fake identities? The court is explicitly authorized to confiscate all profits generated through these fraudulent practices, rescind share allocations obtained through false or misleading identities, transfer all illegally acquired funds directly to the Investor Education and Protection Fund, impose substantial financial penalties commensurate with the violation's severity, initiate criminal prosecution in particularly egregious cases of fraud. Why is this regulation essential? This regulation safeguards market integrity by preventing individuals from securing unfair advantages in oversubscribed offerings, protecting legitimate investors from artificial scarcity created by fraudulent applications, ensuring transparent, fair, and equitable allocation of securities, preserving public confidence in the integrity of securities markets. How does this provision connect to other securities regulations? Section 38 functions in conjunction with complementary securities law provisions to strengthen comprehensive anti-fraud mechanisms within the securities ecosystem, support SEBI's fundamental mandate to safeguard investor interests, reinforce transparency requirements governing all securities transactions, establish clear accountability standards for all participants in the share application process, allotment of securities. Frequently asked questions. Companies must satisfy minimum subscription thresholds, collect requisite application fees, and submit proper documentation when allotting securities, or refund investors if requirements remain unfulfilled. What is required before securities can be allotted? Prior to allotment, companies must secure the minimum subscription amount specified in their prospectus, generally 90% of the issue size. SEBI may establish alternative requirements for specific offerings. Companies must confirm that all subscription funds have been appropriately received and documented before executing the allotment process. How much money must accompany the application? Applicants must submit at least 5% of the security's nominal value with their application, unless SEBI designates a different threshold. For debentures and certain securities, this minimum requirement may be elevated. All application payment specifications must be transparently outlined in the company's prospectus. What occurs if the minimum subscription threshold isn't met? If a company fails to achieve the minimum subscription within 30 days, or SEBI's designated time frame, it must reimburse all application funds within the stipulated period. Any reimbursement delays incur 15% annual interest. Furthermore, the company is prohibited from launching another public offering for a minimum of 6 months following such a shortfall. What obligations do companies have after securities allotment? Following allotment, companies must submit a comprehensive return of allotment to the registrar in the prescribed format, specifying allottees, securities distributed, and consideration received. Companies must issue allotment letters or certificates within the statutory time frame and promptly update their member registry, who supervises the allotment process to ensure compliance. The company's board of directors governs the entire allotment procedure, with specific verification conducted by the audit committee. For listed entities, stock exchanges monitor adherence to listing requirements throughout the process. The company's compliance officer ensures conformity with all regulatory standards. Are allotments permitted to related parties or promoters? Allotments to related parties, promoters, or directors are authorized but subject to substantial restrictions. These must be explicitly disclosed in the prospectus and undergo heightened scrutiny by SEBI and stock exchanges. Any preferential allotments to these groups necessitates shareholder approval and must adhere to SEBI's preferential issue guidelines. What penalties exist for improper allotment procedures? Improper allotment may trigger significant sanctions, including monetary penalties for the company and its officers. SEBI may issue cease and desist orders, mandate investor compensation, or restrict the company's capital market access. Directors may face personal liability for non-compliance, and investors may pursue civil remedies for losses stemming from improper practices. Frequently asked questions about securities and stock exchanges before initiating public offerings. Companies must obtain stock exchange approval, maintain separate bank accounts for investor funds, use these funds exclusively for authorized purposes, and comply with regulatory requirements when paying commissions to subscription facilitators. These measures protect investor interests and ensure capital market integrity. What permission does a company need before offering securities to the public? Companies must secure approval from at least one recognized stock exchange before making any public offer. The company must specifically name this stock exchange in their prospectus. This requirement ensures that securities meet essential listing standards and regulatory criteria before being offered to the public. Where must companies keep the money received from investors? All funds received from investors must be deposited into a separate, dedicated bank account with a scheduled commercial bank. This segregation safeguards investor money until securities are properly allocated, preventing commingling with the company's operational funds. When can companies use the money received from investors? Companies may only utilize these funds under two specific conditions: when allocating securities that have received stock exchange trading approval, or when refunding investors if securities cannot be allocated. These funds must remain untouched for any operational or corporate purposes until proper allocation is completed. Can companies pay commissions to people who help find investors? Yes. Companies may pay commissions to subscription facilitators, provided they strictly follow regulatory guidelines. These commission arrangements must be fully disclosed in the prospectus and must remain within the limits established by the relevant regulatory authorities. What disclosures are required in a company's prospectus regarding securities? Companies must provide comprehensive information including detailed risk factors, audited financial statements, current capital structure, issue objectives, business model description, management qualifications, and complete offer terms. All material information that could reasonably influence an investor's decision-making process must be accurately and thoroughly disclosed. How are investor grievances addressed in the securities market? Companies must establish robust investor grievance redressal mechanisms with clear procedures and timelines. Both stock exchanges and SEBI provide supplementary platforms for addressing investor complaints. Companies must document, report, and resolve all investor grievances within strictly specified timeframes to maintain their good standing and preserve their listing status. Frequently asked questions about Global Depository Receipts. Global Depository Receipts, GDRs, are negotiable certificates issued by international banks representing shares in foreign companies. They require special corporate approval and enable businesses to access global capital markets while enhancing international visibility and trading liquidity. What approval does a company need to issue GDRs? Companies must secure a special resolution during their general meeting before issuing depository receipts in any foreign country, as required by Section 41 of the Companies Act. This resolution must clearly specify the target markets and the approximate number of shares to be represented. What is a global depository receipt? A global depository receipt, GDR, is a bank-issued certificate representing ownership of shares in a foreign company. These instruments facilitate trading of a company's shares on markets outside their home country. Each GDR may represent one or multiple underlying shares of the issuing company. Why do companies issue GDRs? Companies issue GDRs to access international capital beyond their domestic markets. This approach diversifies their investor base, enhances global brand visibility, improves share liquidity, and potentially lowers capital costs through expanded market exposure. Who administers GDRs? Major international banks serve as depositories that create, issue, and manage GDRs in foreign markets. These institutions hold the underlying shares, issue corresponding GDRs for trading on foreign exchanges, and manage all administrative functions including dividend payments and corporate actions. How do GDRs differ from ADRs? While American depository receipts, ADRs, specifically trade in the United States under SEC oversight, GDRs can trade in multiple international markets. Both instruments facilitate cross-border investment, but follow different regulatory frameworks based on their respective trading locations. What documentation is required for GDR issuance? Companies must prepare detailed offering circulars or prospectuses containing corporate information, financial statements, risk factors, and specific GDR terms. These documents must comply with the disclosure requirements of the foreign exchanges where the GDRs will list. How are dividends processed for GDR holders? When companies declare dividends, the depository bank receives payments in the local currency, converts them to the GDR's trading currency, and distributes them to GDR holders. This process simplifies cross-border dividend payments for international investors.
Frequently asked questions about private placement. Private placement allows companies to offer securities to a select group, maximum 50 individuals per financial year, through designated forms. Companies must follow specific protocols and deliver securities within 60 days of receiving payment, or return funds with interest. What is a private placement? A private placement occurs when a company offers securities to a select group of sophisticated investors, rather than the general public. This offering must be conducted through a specialized application form, as stipulated in Section 42 of the Companies Act. How many people can receive a private placement offer? A maximum of 50 individuals in a financial year. This limit specifically excludes qualified institutional buyers, such as banks and insurance companies, and employees receiving shares through employee stock option schemes. What steps must companies follow for private placement? Companies must use official forms when extending these offers and maintain comprehensive records of all individuals receiving the offers. Investors must complete the designated application forms and submit payment exclusively through banking channels. How long does it take to get shares after applying? Companies must deliver securities within 60 days of receiving payment. If they fail to meet this deadline, they must refund the investment within 15 days along with 12% annual interest, calculated for the entire delay period. What information must be included in a private placement offer? The offer letter must contain comprehensive details about the company's financial position, business operations, purpose for raising capital, and price justification. It must also disclose any significant legal proceedings and identify all directors who have approved the offer. Are there any restrictions on using the money raised? Yes. Funds acquired through private placement must be utilized exclusively for the specific purposes outlined in the offer document. Companies are strictly prohibited from using these funds to purchase, trade, or otherwise engage with securities of any other companies. Do companies need special approval for private placement? Yes. Companies must secure prior shareholder approval through a special resolution. All securities must be allotted within 12 months from the date this resolution is passed, or the approval becomes invalid. How is private placement different from public offering? Private placement involves offering securities to a select group of investors without public advertisement, while public offerings are open to the general public and require a detailed prospectus. Private placements involve fewer regulatory requirements, lower costs, and typically faster implementation than public offerings. Chapter 4: Share Capital and Debentures. Frequently asked questions. This chapter governs how companies manage securities, including various share types, issuance procedures, transfers, buybacks, and debentures. These comprehensive regulations ensure corporate compliance and investor protection through transparent practices and proper disclosures. What is share capital? Share capital represents the total funds a company raises by issuing shares. The Companies Act clearly defines different types of share capital: equity and preference shares, which represent ownership interests and constitute the foundation of a company's financial structure. How are securities regulated under this chapter? This chapter establishes robust rules for issuing shares and debentures, mandates specific disclosures, and sets stringent management standards to protect investors. Companies must adhere to prescribed procedures for public offerings, rights issues, bonus shares, and preferential allotments to maintain transparency. What are the basic transfer provisions? The chapter delineates precise documentation requirements and timelines for transferring shares between parties. Companies must register valid transfers within 15 days of receiving proper documentation and issue certificates accordingly. Can companies buy back their own shares? Yes, but within specific limitations. Buybacks are restricted to 25% of the total paid-up capital and free reserves per financial year, and necessitate authorization through both board approval and a special shareholder resolution. What are debentures? Debentures are debt instruments that formally acknowledge a company's obligation to repay principal with interest. This chapter regulates their issuance, security requirements, and redemption processes, including mandatory debenture redemption reserves and trustee appointments. What disclosures are required when issuing securities? Companies must provide comprehensive information in their offer documents, including detailed financial status, business operations, risk factors, and specific funding purposes. Penalties for misleading statements or material omissions are particularly severe. How does this chapter protect minority shareholders? Protection is ensured through provisions requiring special or majority resolutions for certain corporate actions, preventing dominant shareholders from making unilateral decisions. The chapter also stringently regulates related party transactions and prohibits insider trading. What are the penalties for non-compliance? Violations can result in substantial fines for both the company and its officers, potential imprisonment for willful non-compliance, and various remedial orders. Regulatory authorities possess broad investigation and enforcement powers to ensure adherence. Frequently asked questions. Share capital. Share capital is divided into two principal categories: equity shares, which may carry voting rights, and preference shares, which provide priority for dividend payments and capital repayment during liquidation. What are the main types of share capital? Companies can generate capital through two primary share classifications: equity share capital and preference share capital. Each represents a distinct ownership structure with unique rights, privileges, and financial implications. What is equity share capital? Equity share capital encompasses all share capital not classified as preference share capital. According to Section 43 of the Companies Act, it includes shares with standard voting rights, shares with differential rights regarding dividends, voting power, or other specified benefits. Equity shareholders constitute the true owners of the company and typically possess voting rights proportionate to their shareholding, enabling them to participate in corporate governance. What is preference share capital? Preference share capital provides investors with two fundamental advantages: priority in dividend distribution, at a predetermined fixed amount or rate; preferential repayment of invested capital should the company undergo liquidation. However, preference shareholders generally lack voting rights except in specific circumstances that directly affect their established legal entitlements. Are existing preference shareholders protected? Yes. The Act expressly safeguards the rights of preference shareholders who are entitled to capital repayment upon company dissolution prior to the Act's implementation, ensuring continuity of their investment expectations. Can companies issue different classes of shares? Yes. Companies have considerable flexibility to issue various classes of shares with distinct rights regarding dividend entitlements and distribution schedules, voting privileges and decision-making participation, redemption provisions and procedures, participation in surplus asset distribution during liquidation. What are the voting rights of equity shareholders? Equity shareholders typically exercise one vote per share on significant matters requiring shareholder approval, including election and removal of directors, ratification of financial statements, and annual reports. Critical corporate decisions affecting company structure, constitutional amendments to foundational documents. Can preference shares be converted to equity shares? Yes, if structured as convertible preference shares. This sophisticated arrangement grants holders the option to transform their preference shares into a predetermined number of equity shares after a specified period, or upon the occurrence of defined triggering events, such as funding rounds or performance milestones. What disclosures are required when issuing different types of shares? Companies must comprehensively disclose the rights attached to each share class in their Memorandum of Association, defining the company's relationship with external stakeholders, Articles of Association, governing internal management procedures, share certificates, documenting individual ownership, offer documents, providing information to potential investors. Frequently asked questions about shares. Shares constitute movable property with unique identification numbers that can be transferred according to company articles, with specific exemptions for shares maintained in depository systems. What type of property are shares considered? Shares are classified as movable property, enabling transfer between individuals according to the company's articles. Unlike immovable property such as real estate, share ownership changes through documentation rather than physical relocation of assets. Can shares be transferred to someone else? Yes, shares are fully transferable. The transfer process is detailed in the company's articles and typically involves completing a transfer form with signatures from both parties, followed by updating the company's official ownership registry. Do shares have identification numbers? Yes, each share must carry a unique identification number, called a distinctive number. This numbering system is crucial for tracking ownership and maintaining accurate records of all share transactions throughout the company's lifetime. Are there any exceptions to the numbering rule? Yes, shares held by individuals listed as beneficial owners and depository records are exempt from the distinctive numbering requirement. In modern electronic trading systems, these shares are tracked through secure digital ledgers rather than physical numbered certificates. What rights do shareholders typically have? Shareholders generally enjoy several fundamental rights, including receiving declared dividends, participating in voting in general meetings, accessing annual financial statements, and claiming proportional assets during company liquidation. These rights may vary based on the specific share class held. Can a company restrict the transfer of shares? Yes. Private companies often incorporate transfer restrictions in their articles of association. These typically include preemption rights, giving existing shareholders first opportunity to purchase shares being sold, and board approval requirements before admitting new shareholders. What is the difference between issued shares and authorized shares? Authorized shares represent the maximum number of shares a company may issue as specified in its constitution, while issued shares are those actually allocated to shareholders. Companies typically authorize more shares than initially issued to maintain flexibility for future capital raising without amending their foundational documents. Share certificates. Frequently asked questions. Share certificates serve as legal proof of ownership, can be replaced if lost or damaged, and are unnecessary for electronically held shares where depository records constitute sufficient ownership evidence. What is the legal value of a share certificate? A share certificate establishes your ownership in a company. When it bears the company's seal or signatures from 2 directors, or 1 director and the company secretary, it serves as legal evidence of your shareholding. Courts and regulatory authorities accept it as prima facie proof of ownership, entitling you to all corresponding shareholder rights. What if I lose my share certificate? If your certificate is lost or damaged, you can obtain a replacement by submitting evidence of the certificate's loss or destruction, returning the damaged certificate, if applicable, completing an indemnity form to safeguard the company against potential fraud, paying any applicable administrative fees. The company will issue a duplicate certificate after thoroughly verifying your request. How does share ownership work with electronic shares? For electronically held shares in a depository system, the depository's records function as ownership proof without requiring any physical certificate. These electronic records, maintained by depository participants, typically banks or brokerage firms, hold complete legal validity. This dematerialized system eliminates risks inherent to physical certificates, including theft, forgery, and damage. What information appears on a share certificate? A standard share certificate contains the company's name and registration number, the shareholder's name and address, the quantity and class of shares represented, the distinctive numbers assigned to the shares, the issuance date, the company seal, and required signatures. How long does it take to receive a share certificate? Companies must typically issue certificates within 2-3 months following share allotment or transfer registration. Many organizations process these requests more efficiently, usually within 2-4 weeks. The exact timeline varies according to company policies and jurisdictional regulations. Are physical share certificates becoming obsolete? Yes, physical share certificates are declining rapidly with the proliferation of electronic trading systems and dematerialization initiatives. Many jurisdictions now actively encourage or mandate electronic shareholding for publicly traded companies, though some private enterprises and specific markets still utilize physical certificates. The industry is progressively transitioning toward fully electronic systems due to their superior efficiency, enhanced security features, and cost-effectiveness. Voting rights. Frequently asked questions. Equity shareholders possess comprehensive voting rights on all company matters, while preference shareholders typically have limited voting privileges unless dividend payments remain unpaid for 2 consecutive years. These voting mechanisms are explicitly governed by Section 47 of the Companies Act. Who can vote at company meetings? All equity shareholders possess the right to vote on company matters. Your voting power corresponds directly to your paid-up equity share capital, adhering to the fundamental one share, one vote principle. This democratic decision-making process occurs during annual general meetings, AGMs, or extraordinary general meetings, EGMs. Can preference shareholders vote? Generally, preference shareholders may only vote on resolutions that directly affect their specific rights during company liquidation proceedings or when their capital is being repaid. This limitation reflects the balance between their priority status for dividend distributions and their reduced participation in company governance. Are there exceptions for preference shareholders? Yes. If a company fails to distribute dividends to preference shareholders for 2 or more consecutive years, these shareholders automatically gain full voting rights on all company matters. This critical safeguard ensures preference shareholders can actively protect their investments when dividend commitments remain unfulfilled. What does Section 47 of the Companies Act specify about voting? Section 47 establishes the comprehensive voting framework, ensuring appropriate voting rights based on share classification. It explicitly stipulates that equity shareholders have voting rights on all resolutions placed before the company, while preference shareholders have conditional voting rights that activate under specific prescribed circumstances. How can I exercise my voting rights if I'm unable to attend a meeting? You may appoint a proxy to vote on your behalf if personal attendance isn't possible. Submit a properly completed proxy form to the company within the designated time frame, typically 48 hours before the scheduled meeting. Importantly, your proxy representative need not be another shareholder of the company. What's the difference between a poll vote and a show of hands? Most routine resolutions are decided via a show of hands, where each member physically present receives 1 vote regardless of their shareholding percentage. However, shareholders can demand a poll vote, which allocates votes based on actual shares owned, thereby providing a more precise representation of proportional shareholder interests. Can voting rights vary within the same class of shares? No. The Companies Act mandates uniform voting rights for all shares within the same classification. Companies wishing to implement different voting structures must establish separate and distinct share classes, each with clearly defined and differentiated rights. Common questions about shareholders' rights. Section 48 governs modifications to shareholder rights, requiring 75% approval from affected shareholders. Minority shareholders, holding G10%, can petition the tribunal against such changes within 21 days. All parties must comply with the tribunal's final determinations. How can shareholders' rights be modified? Under Section 48, rights of any share class can be modified with written consent or special resolution from at least 3/4 of those shareholders. This substantial threshold ensures that significant changes require overwhelming majority support. What recourse do I have if I oppose changes to my shareholder rights? If you hold at least 10% of the affected shares and disagree with the modifications, you may petition the tribunal within 21 days of approval to cancel them. Your petition should clearly articulate your objections and demonstrate how these changes potentially harm your interests. Who must adhere to the tribunal's decision? All shareholders are bound by the tribunal's ruling, regardless of their initial position. The company must file this decision with the registrar within the stipulated time frame to ensure proper documentation and regulatory compliance. What does the tribunal review process involve? Upon receiving your petition, the tribunal conducts a comprehensive assessment of the proposed modifications and their potential impact on various shareholder groups. All affected parties may present their arguments before the tribunal, renders a decision based on principles of fairness and legal requirements. Are there exceptions to the 75% approval requirement? Yes. Certain circumstances outlined in the company's articles or memorandum of association may establish different approval thresholds. Additionally, regulatory authorities may impose alternative requirements for specific industries or company categories. Can the company purchase shares from dissenting shareholders? Yes, in certain situations, the company may offer to buy out dissenting shareholders at fair market value as an alternative to implementing contested changes. This approach can resolve conflicts while allowing the company to proceed with necessary modifications. These provisions establish a balanced framework that protects both majority and minority shareholder interests when rights require modification, preserving corporate flexibility while safeguarding individual investor protections. Companies should consult legal counsel before initiating any changes to ensure complete compliance with all statutory requirements. Frequently asked questions about calls on shares. Companies must ensure equitable treatment by making uniform calls on shares within the same class. Shares with different paid-up amounts constitute separate classes even when their face value is identical. How must companies make calls for further share capital? Companies are required to make calls on a uniform basis for all shares within the same class. This requirement ensures equal treatment of all shareholders when requesting additional payment for partly paid shares, preventing preferential treatment or discrimination. Can shares with different paid-up amounts be treated as the same class? No. Shares are categorized as different classes if they have different paid-up amounts, even when they possess identical face value. This distinction is essential for maintaining equity and capital call procedures. What does Section 49 of the Companies Act require? Section 49 safeguards shareholder equity by mandating that companies must require identical amounts from all shareholders holding the same class of shares when requesting additional payments. This provision prevents selective capital calls that could disadvantage certain shareholders. What precisely is a call on shares? A call on shares represents a formal demand by a company for shareholders to remit all or part of the outstanding balance on their partially paid shares. The board of directors determines the timing and amount of these calls based on the company's capital requirements and financial strategy. What notice requirements exist for calls on shares? Companies must provide shareholders with sufficient advance notice before a call payment becomes due. The notice period is typically specified in the company's articles of association, commonly ranging from 14 to 30 days, allowing shareholders adequate time to arrange payment. What consequences result from failing to pay a call on shares? Non-payment of a call by the stipulated deadline typically results in interest charges accruing on the unpaid amount at a rate specified in the articles. Continued non-compliance may ultimately lead to share forfeiture, wherein you lose all ownership rights and previously paid amounts. Can a company modify a call after it has been issued? Yes. The board of directors retains the authority to postpone payment deadlines, extend grace periods, or even cancel a call entirely if warranted by business circumstances. However, any such modifications must be implemented uniformly across all shareholders of the same class to maintain equity. A thorough understanding of these regulations enables both companies and shareholders to navigate their respective rights and obligations regarding partly paid shares and capital calls. Promoting transparency and fair corporate governance and capital management procedures. Payment of uncalled capital. Frequently asked questions. Shareholders may pay for unpaid shares in advance when company articles permit it. though no additional voting rights are granted until an official call is made. Can I pay for my shares in advance? Yes. Section 50 of the Companies Act permits shareholders to pay the unpaid amount on their shares before the company formally requests it, provided the company's articles of association allow such advance payments. If I pay in advance, will I gain additional voting rights? No. You will not receive any additional voting rights for advance payments until the company officially makes a call for that payment from all shareholders in the same class. Your voting rights remain tied to the called-up portion of your shares. Will I receive interest on advance payments? Yes. If you make advance payments on your shares, the company may pay interest on that amount, but only if their articles of association explicitly authorize it and at the rate specified therein. This interest serves as compensation for providing capital before it was formally required. What happens if the company never calls for the capital I paid in advance? Your advance payment remains with the company as paid in capital until a formal call is made. If the company undergoes liquidation before making the call, you would rank as a creditor for the advance payment amount, giving you priority over other shareholders in the distribution of assets. Can the company refuse my advance payment? Yes. The company is not obligated to accept advance payments unless their articles specifically require acceptance. The board of directors typically maintains discretion in this matter based on the company's financial needs and strategic objectives. Is there a tax benefit to paying uncalled capital in advance? Tax implications vary by jurisdiction and individual circumstances. In some cases, interest received on advance payments may be subject to income tax. Additionally, the timing of payments may affect capital gains tax calculations. Consulting with a qualified tax professional regarding your specific situation is advisable before making advance payments. Understanding these provisions helps shareholders make informed decisions about advance payments on partly paid shares, while ensuring compliance with company regulations. Payment of dividend. Frequently asked questions. Dividends may be distributed proportionally based on shareholders' paid-up amounts rather than merely share counts, ensuring equitable profit distribution when authorized by company articles. How are dividends paid to shareholders? According to Section 51 of the Companies Act, companies may distribute dividends in proportion to the amount actually paid on each share, provided the company's articles permit this method. This ensures profit distribution reflects actual capital contributions made by shareholders, rather than simply the number of shares held. Do all shareholders receive equal dividend amounts? No. Shareholders who have contributed more capital per share may receive proportionally larger dividends. This differential distribution ensures those who have paid more receive commensurate rewards. For example, if shareholder A has paid 5 per share while shareholder B has paid 7 per share, shareholder B would receive 40% more dividend per share. What is the rationale behind a proportional dividend distribution? This provision ensures equitable profit sharing. Shareholders who have invested more capital receive a proportionally greater share of profits. Recognizing varying levels of financial commitment and appropriately rewarding those who have made larger capital contributions toward the company's operations and growth. Is proportional dividend distribution automatically applicable to all companies? No. This provision applies only when expressly included in a company's articles of association. Without such specification, standard dividend distribution typically occurs based on nominal share ownership, regardless of the amount paid up on each share. When may a company declare dividends? Companies may declare dividends only from current year profits, accumulated profits from previous years, funds provided by the government specifically for dividend payments, or from general reserves, excluding capital reserves. All applicable legal requirements must be satisfied before any dividend declaration. What restrictions exist on dividend payments? Companies cannot declare or pay dividends if they have defaulted on deposit repayments or interest payments. Additionally, companies must transfer a statutorily mandated percentage of profits to reserves before distributing dividends, and must ensure that such distributions will not impair the company's ability to meet its financial obligations. How do partially paid shares affect dividend entitlements? For partially paid shares, dividends are generally calculated proportionate to the paid-up amount. For instance, if a share has a face value of 10 but only 5 has been paid, the shareholder would receive dividends based on the 5 contributed amount rather than the face value, unless the company's articles specify an alternative arrangement. Securities Premium Account FAQs. The Securities Premium Account captures premium amounts received when shares are issued above face value. This specialized capital reserve operates under strict regulatory controls and receives the same legal protection as paid-up share capital. What is a Securities Premium Account? When a company issues shares at a price exceeding their face value, the differential amount must be credited to a specialized reserve called the securities premium account. This account receives the same statutory protection as paid-up share capital and is subject to similar regulatory constraints. For instance, if shares with a face value of 10 are issued at 15 per share, the additional 5 per share must be transferred to the securities premium account, rather than being recorded as ordinary income. What are the permitted uses of the securities premium account? The Companies Act strictly limits securities premium utilization to these specific purposes: issuing fully paid bonus shares to existing shareholders, writing off preliminary expenses incurred during company formation, covering expenses, commissions, or discounts related to securities issuance, providing premium payable on redemption of preference shares or debentures, financing company share buy-backs under Section 68, writing off company preliminary expenses, writing off expenses or commission paid for issuing securities. Any application of these funds must adhere strictly to Section 52 provisions of the Companies Act, 2013. Is the securities premium account considered part of the company's capital? Yes, the securities premium account functions effectively as capital for most regulatory and accounting purposes. It follows similar capital reduction procedures and maintenance rules as share capital. On the balance sheet, the securities premium account appears under reserves and surplus on the liabilities side, reflecting its status as a capital reserve rather than revenue profit. Can securities premium be distributed as dividends? No, the securities premium account cannot be distributed as dividends under any circumstances. This prohibition exists because securities premium represents capital contribution, not operational profit. Distributing it as dividends would constitute unauthorized capital reduction and violate fundamental capital maintenance principles. How does the securities premium account differ from general reserves? The securities premium account fundamentally differs from general reserves in source, purpose, and flexibility. While general reserves typically originate from accumulated profits, securities premium derives exclusively from capital transactions. General reserves can be utilized at board discretion, subject to reasonable limitations, whereas securities premium may only be applied toward the specific statutory purposes enumerated in the Companies Act. Is maintaining a securities premium account mandatory? Yes, maintaining a securities premium account is mandatory whenever shares are issued at a premium. This statutory requirement under the Companies Act cannot be circumvented through company articles or shareholder resolutions. Companies must maintain detailed transaction records for this account and ensure full compliance with prescribed accounting standards for capital reserves. Frequently asked questions. Shares at discount. Section 53 of the Companies Act, 2013 expressly prohibits issuing shares at a discount, with narrowly defined exceptions for debt restructuring scenarios and sweat equity shares. Non-compliance attracts substantial penalties for both the company and its officers, necessitating strict adherence to statutory provisions. Can a company issue shares at a discount? No. Section 53 of the Companies Act, 2013 categorically prohibits companies from issuing shares below their nominal or face value at a discount. Sweat equity shares under Section 54 represent the primary statutory exception, subject to specific regulatory requirements and procedural compliance. Any shares issued at a discount are void ab initio and create significant legal and regulatory complications. This prohibition applies uniformly across all company classifications, private, public, listed, and unlisted entities. Are there any exceptions to this rule? Yes. Companies may issue shares at a discount to creditors when converting debt into equity as part of a formal debt restructuring mechanism. This exception applies exclusively under statutory resolution plans or debt restructuring schemes formally sanctioned by the Reserve Bank of India or pursuant to proceedings under the Insolvency and Bankruptcy Code. Such conversions must strictly comply with prescribed regulatory guidelines and require comprehensive documentation and disclosure. Each application is evaluated independently, with companies required to substantiate genuine financial distress warranting such exceptional treatment. What happens if a company issues shares at a discount? The company faces financial penalties up to the amount raised through the discounted share issuance or 5 lakh rupees, whichever is lower. Additionally, the company must refund all monies received from investors with 12% annual interest calculated from the date of issuance. Officers responsible for the contravention may face severe penalties under Section 447 for fraud, including potential criminal liability. Shareholders who knowingly received such shares may also face regulatory scrutiny and potential disgorgement of benefits. What is the historical context of this prohibition? This prohibition serves as a fundamental investor protection mechanism, safeguarding existing shareholders' interests and maintaining market integrity. Under the previous Companies Act, 1956, shares could be issued at a discount under exceptional circumstances with explicit court approval. The Companies Act, 2013 substantially strengthened this prohibition to prevent capital dilution and enhance investor protection standards. This alignment with international corporate governance frameworks discourages arbitrary share price manipulation and ensures capital adequacy. How does this relate to share premium? While discount issuance is prohibited, companies retain the flexibility to issue shares at a premium, above face value, based on prevailing market conditions and substantiated company valuation. Premium amounts must be transferred to a dedicated securities premium account with statutorily restricted uses as precisely enumerated in the Act. This regulatory asymmetry, permitting premiums while prohibiting discounts, reflects legislative intent to maintain capital adequacy and preserve shareholder value. Sweat equity shares. Frequently asked questions. Sweat equity shares are a specialized form of compensation awarded to directors or employees for their intellectual contributions. While the Companies Act prohibits issuing shares at a discount, sweat equity shares represent a significant exception under specific regulatory frameworks. What are sweat equity shares? Sweat equity shares are equity shares issued to company directors or employees as compensation for providing intellectual property rights, know-how, or value additions beyond their standard duties. These shares acknowledge the sweat, intellectual effort, and expertise contributed, creating a non-cash incentive that aligns employee interests with organizational success. Can companies issue shares at a discount? Section 53 of the Companies Act, 2013 generally prohibits companies from issuing shares below their face value. However, Section 54 specifically exempts sweat equity shares from this restriction. This exception recognizes the intrinsic value of knowledge-based contributions that may be difficult to quantify through conventional valuation methods. What approvals are needed to issue sweat equity shares? Issuing sweat equity shares requires a special resolution with approval from at least 75% of voting shareholders. The resolution must clearly detail the number of shares, current market value, consideration received, and recipient identities. This rigorous approval mechanism ensures corporate governance standards and safeguards existing shareholder interests. Are there different rules for different types of companies? Yes. Regulatory requirements vary by company classification. Listed companies must follow Securities and Exchange Board of India (SEBI) regulations, while unlisted companies must adhere to the Companies Act, 2013 and its associated rules. These tailored frameworks reflect the different levels of oversight needed for various corporate structures. Do sweat equity shares have the same rights as regular shares? Once issued, sweat equity shares carry identical rights and privileges as other equity shares in the same class. This includes equivalent voting rights, dividend entitlements, and liquidation benefits, ensuring recipients receive full shareholder privileges proportionate to their contributions. Are there any limits on issuing sweat equity shares? Companies face annual issuance limits of 15% of paid-up equity capital or shares valued at 25 crore rupees, whichever is higher. The total lifetime cap is 25% of the company's paid-up equity capital. These thresholds preserve capital structure integrity while enabling meaningful recognition of intellectual contributions. Is there a lock-in period for sweat equity shares? Yes, a mandatory 3-year lock-in period applies from the allotment date, during which recipients cannot transfer or sell these shares. This restriction ensures sustained commitment from key contributors and prevents immediate monetization of these specialized compensation instruments. Can startups issue sweat equity shares? Startups enjoy greater flexibility with permission to issue sweat equity shares up to 50% of their paid-up capital for double the standard limit. This accommodation reflects startups' heavy reliance on intellectual capital and their cash constraints when competing to attract and retain essential talent. Preference shares. Frequently asked questions. Preference shares grant priority benefits to holders but must be redeemed within 20 years. Companies can only redeem these shares under specific regulatory conditions, using either accumulated profits or proceeds from new share issuances. What are preference shares? Preference shares provide holders with distinct advantages over common shareholders, including priority in dividend distributions and preferential treatment during company liquidation. These shares establish a hybrid security that combines features of both equity and debt. Can companies issue preference shares that never expire? No. Section 55 of the Companies Act explicitly prohibits the issuance of irredeemable preference shares. All preference shares must have a specified redemption date, occurring within 20 years from their date of issuance. Are there any exceptions to the 20-year redemption rule? Yes. Infrastructure development projects may qualify for extended redemption periods, but they must adhere to a structured redemption schedule with a specific percentage of shares being redeemed annually throughout the extended time frame. When can a company redeem preference shares? A company may only redeem preference shares when all of the following regulatory conditions are satisfied. Redemption must utilize profits that would otherwise be available for dividend distribution, or funds generated from fresh issuance of shares. The shares must be fully paid up by the shareholders. An amount equal to the nominal value of redeemed shares must be transferred to a capital redemption reserve account. When using profits for redemption, any premium payable upon redemption must be sourced from distributable profits or the securities premium account. What types of preference shares can companies issue? Companies can issue various categories including cumulative preference shares, where unpaid dividends accumulate for future payment, non-cumulative preference shares, participating preference shares, which entitle holders to share in surplus profits beyond a fixed dividend rate, and convertible preference shares, which can be converted into equity shares under predetermined terms and conditions. Do preference shareholders have voting rights? Generally, preference shareholders possess limited or no voting rights in company affairs. However, they may acquire full voting rights in specific circumstances, such as when dividend payments have remained unpaid for a statutorily prescribed period, or on resolutions directly affecting their rights and privileges. What happens to preference shares during liquidation? During company liquidation proceedings, preference shareholders receive priority in capital repayment before ordinary shareholders. This capital repayment priority constitutes one of the fundamental advantages of holding preference shares as an investment class. Can preference shares be issued at a discount? No. Companies are statutorily prohibited from issuing preference shares at a discount to their face value. These shares must be issued either at par value or at a premium above the established par value. What disclosure requirements exist for preference share issuance? Companies must provide comprehensive disclosures regarding preference shares in their financial statements, including detailed redemption terms, dividend rights, participation features, conversion options, and any other special rights available to preference shareholders. Transfer and transmission of securities. Frequently asked questions. Securities can be transferred through proper documentation within 60 days or transmitted by operation of law. Companies must issue certificates within specific time frames, ranging from 1 to 6 months depending on the transaction type. Frequently asked questions. What do I need to transfer securities? You need a properly stamped, dated, and signed transfer document submitted to the company within 60 days of signing. The document must clearly identify the securities being transferred and include complete details of both the transferor and transferee. How does transmission of securities work? Transmission occurs when securities pass to someone by operation of law rather than through voluntary transfer. Unlike transfers, transmission happens automatically due to events like death, insolvency, or marriage. The recipient must notify the company with supporting documentation such as death certificates, probate, or succession certificates. When will I receive my security certificates? Companies must issue certificates within these specific time frames, within 2 months for newly issued securities, within 1 month for transfers, and up to 6 months for transmissions, depending on the complexity of the case. Can I transfer securities to multiple people? Yes, securities can be transferred to multiple individuals by naming all transferees in the transfer document. All transferees will become joint holders with rights as specified in the company's articles of association. What happens if my transfer document is defective? The company must notify you within 15 days of receiving a defective transfer document. The notice will detail the specific defects and provide a time frame for corrections. Failure to address these issues within the specified period may result in rejection of the transfer. Are there any restrictions on transferring securities? Yes, restrictions may exist based on the company's articles of association or shareholder agreements. Some securities have mandatory lock-in periods prohibiting transfers. Additionally, transfers that would violate any law, such as exceeding foreign investment limits, cannot be processed. What documents are needed for transmission in case of death? Legal heirs or nominees must submit a death certificate along with a succession certificate, probate of will, or letter of administration, as applicable. For jointly held securities, surviving holders typically need to provide only the death certificate to establish their continuing ownership. Punishment for personation. Frequently asked questions. Personation involves fraudulently impersonating a securities owner to misappropriate assets or funds. Offenders face imprisonment of 1-3 years and fines between 1 and 5 lakh. This legal provision protects legitimate owners and maintains the integrity of the financial system. Frequently asked questions. What constitutes personation under Section 57? Personation occurs when someone falsely represents themselves as the rightful owner of securities, interests, share warrants, or coupons with the intent to wrongfully acquire these assets or related funds. This fraud typically involves creating forged documents, assuming false identities, or impersonating deceased individuals. What penalties do personators face? Upon conviction, offenders receive imprisonment ranging from 1 to 3 years and fines between 1,100,000 and 5,500,000. Courts may additionally order compensation to victims based on the financial damage inflicted. Why is personation considered a serious offense? Personation represents a significant crime because it involves calculated deception aimed at stealing another's property or funds. This criminal act not only harms legitimate owners but also undermines trust in financial markets, potentially damaging investor confidence in the entire securities framework. Who does Section 57 protect? Section 57 primarily safeguards legitimate owners of company securities, interests, share warrants, and coupons from fraudulent misappropriation. By extension, it also protects companies, financial institutions, and the broader investment ecosystem from such fraudulent activities. How is personation typically detected? Personation is usually identified through verification procedures implemented by companies and transfer agents, including signature validation, identity document verification, and legal paperwork authentication. Many organizations now employ biometric verification and advanced technological solutions to prevent such fraud attempts. Is attempting to personate also punishable? Yes, merely attempting to impersonate a securities owner with the intention of obtaining securities or dividends constitutes a punishable offense. The law does not require successful completion of the fraudulent act for prosecution. How does personation differ from other forms of securities fraud? While many securities frauds involve market manipulation, insider trading, or company information misrepresentation, personation specifically targets ownership rights by assuming the legitimate owner's identity, rather than manipulating security values or misrepresenting information about the securities themselves. What should I do if I suspect I'm a victim of personation? If you suspect someone is impersonating you to access your securities, immediately notify the company's registrar and your depository participant, file a formal complaint with local law enforcement, and consider implementing a temporary freeze on your securities transfers as a precautionary measure. Common questions about registration refusal and appeals. Private companies must provide share transfer refusal notices within 30 days. Shares in public companies remain freely transferable by law. Aggrieved parties can appeal refusals to the tribunal within specified time frames. What happens if a private company refuses to register my share transfer? When a private company declines your transfer request, they must issue a detailed notice within 30 days explaining their decision. This notice should clearly articulate the specific grounds for refusal, typically based on provisions in the company's articles of association or other valid legal reasons. Failure to provide this notice constitutes a breach of the company's statutory obligations. Can I freely transfer shares in a public company? Yes, securities of public companies are inherently transferable by law. This fundamental principle distinguishes public companies from private entities and ensures market liquidity. Any contractual agreements regarding transfers remain valid and enforceable. This transferability right is protected by law to maintain investor confidence and promote efficient capital markets. How can I appeal if my transfer is refused? You may appeal to the tribunal within 30 days of receiving the refusal notice. If no notice was provided, your appeal window extends to 60 days from your original transfer application date. Submit your appeal using the prescribed form, including comprehensive supporting documentation and evidence that substantiates your legitimate claim. What powers does the tribunal have regarding my appeal? The tribunal can either dismiss your appeal or direct the company to register your transfer. They may also award compensation for quantifiable damages you've suffered. Decisions are based on relevant legal provisions, the company's articles, and the evidence presented during proceedings. The tribunal's determinations are legally binding on all parties involved. Can a company impose restrictions on share transfers? Private companies may establish reasonable restrictions through their articles of association. These limitations must be legally valid, transparent, and applied consistently across shareholders. Public companies, however, generally cannot restrict transfers except in specific circumstances expressly permitted by law or regulatory frameworks. What essential information should I include in my tribunal appeal? Your appeal should detail the shares being transferred, key dates, application submission and refusal, the company's stated grounds for refusal, if provided, and your reasoned arguments contesting the refusal. Include supporting documentation such as share certificates, properly executed transfer deeds, all company correspondence, and any additional evidence strengthening your position. What costs are associated with the appeal process? The appeal process requires payment of a prescribed filing fee when submitting your petition to the tribunal. This fee varies based on the value of shares involved in the disputed transfer. You may incur additional expenses for legal representation if you choose to engage counsel to advocate for your interests during the proceedings. Frequently asked questions. Register of Members Section 59 empowers members to petition the tribunal for correction of errors in the company's register of members. The tribunal can order rectifications and award compensation to affected parties. This mechanism ensures accurate membership records and safeguards shareholders' rights. What is rectification of the register of members? Rectification involves correcting inaccuracies in the company's register of members. Under Section 59, members, the company, or aggrieved parties may petition the tribunal to remedy these errors. This process maintains the integrity and currency of the official shareholding record. As the authoritative legal record of share ownership, the register's accuracy is fundamental to effective corporate governance and transparent stakeholder relations. When can someone request rectification? Rectification may be sought when a name is erroneously included in or improperly omitted from the register. There is unjustifiable delay in recording or removing a member's name. Shareholding details are inaccurately documented. Share transfers are not correctly reflected in the register. Joint shareholdings or erroneously recorded applications should be submitted promptly upon discovery of the error to ensure expeditious resolution. What remedies can the tribunal provide? The tribunal may direct the company to rectify the register and award compensation to parties who have suffered quantifiable losses due to the error. Additionally, the tribunal may temporarily suspend share transfers or voting rights pending resolution. In cases of substantial negligence, the tribunal may impose additional sanctions on the company or its officers. The tribunal exercises its discretionary authority based on the specific circumstances and severity of the irregularity. Does rectification affect my share transfer rights? Generally, no. The rectification procedure does not restrict your right to transfer shares or exercise voting privileges unless explicitly ordered by the tribunal. During proceedings, however, the tribunal may issue interim directives to maintain the status quo if there exists potential for irreparable harm. Such temporary restrictions are lifted upon the tribunal's final determination. Who is eligible to apply for rectification? Rectification applications may be submitted by any member whose name is affected in the register, any person aggrieved by an error or omission, the company itself, beneficial owners of shares whose interests are compromised in specific circumstances. Creditors with legitimate interest in the shareholding structure. Affected parties may also file consolidated applications to address interconnected errors in the register. What is the procedure for rectification application? The rectification process entails filing an application with the National Company Law Tribunal using the prescribed format. 1. Submitting comprehensive documentary evidence substantiating the register error. 2. Remitting the applicable application fee. 3. Providing copies of the application to the company and all concerned parties. 4. Participating in scheduled tribunal hearings. 5. Straightforward rectification matters are typically resolved within 2-3 months, while complex disputes may require extended adjudication periods. Common questions about capital disclosure. Companies must display both authorized and paid-up capital with equal prominence in all official documents. Non-compliance results in financial penalties for both the company and its responsible officers. What must companies include when stating their authorized capital? When displaying authorized capital in any notice, advertisement, business letter, or official document, companies must concurrently present their subscribed and paid-up capital. All capital figures must be presented with equal prominence, identical font size, style, and visibility. This requirement applies to all official company communications, whether in print or digital format. The information must be presented with clarity to prevent any misinterpretation regarding the company's actual financial standing. What are the penalties for non-compliance? Companies that fail to comply with this requirement face a fine of 10,000 rupees. Officers responsible for the violation are personally liable for a penalty of 5,000 rupees per occurrence. Recurring violations may trigger enhanced regulatory scrutiny and potential additional sanctions. Non-compliance can significantly damage the company's reputation and erode stakeholder confidence. What is the legal basis for this requirement? This disclosure obligation is established in Section 60 of the Companies Act. The provision universally applies to all company documents that reference authorized capital. It constitutes an essential component of the broader corporate transparency framework. The legislation specifically aims to prevent misleading representations of a company's financial position. Why is accurate capital disclosure essential? It ensures transparency regarding the distinction between maximum permissible capital and actual available financial resources. It prevents companies from creating an exaggerated impression of their financial capacity or organizational scale. It enables investors and stakeholders to make informed decisions based on accurate financial information. It reinforces market integrity by promoting honest business representation practices. Are any companies exempt from these disclosure requirements? No exemptions exist. All registered companies must comply with this provision without exception. The requirement applies uniformly, regardless of a company's capitalization, industry sector, or operational history. Even newly incorporated entities and companies undergoing restructuring must adhere to these disclosure standards. The regulation applies consistently across all business contexts and organizational phases.
I'm rolling with my Starsky. We just want to party. Pretty like Barbie, she doesn't want